With the consent of the other side, I would like to mention item number 15, Lordship. Matter may be listed after 1 week. Appellant side is present on.
You are for the appellant?
I am for the respondent number 124.
You don't. Heard Mr.
D. Kolita.
D. Kolita, learned counsel for respondent number
124.
124, who prays for an adjournment. Why?
There's some personal difficulty.
For some personal difficulty. Also, Miss P. Bothakur, learned counsel for the appellant, who does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Obliged.
May it please the Lordship. Lordship, I beg to mention item number 12, my lord. And can it be taken up on 6th of August, my lord? 2014 matter.
12.
Item 12, my lord. On 6th of August, my lord.
You have informed the other side.
My government is representing, my lord. Item 12.
Heard Mr. M.A. Chaudhary, learned counsel for the appellant. I am not fixing a date. Next week on any date to be fixed by registry.
Fine.
I prays for an adjournment due to personal difficulties. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
I'm deeply opposed.
May please, your Lordship. In item number 4, Lordships, I have filed an affidavit regarding the service of the notice upon the respondent in paper publication. May this affidavit be called for record.
Item number 4, affidavit be called.
May I please, your Lordship? I beg to mention item number 13. I am appearing on behalf of Mrs. N. Soikia. She has been suffering in running fever from last few days. This item may kindly be adjourned for next week.
You have informed the other side.
Yes.
You have informed.
13.
13.
I'm for item number 13, respondent side, your Lordship.
You have any objection?
Lordship, this matter will be abated because the petition already expired and there is already an order on the last day. So matter will be taken up and it may be finally disposed of, your Lordship.
Today?
Yes, your Lordship.
But let
Can
the
be
council,
disposed of.
no, but the council for the,
1-3.
council for the, your name is there in the Wakalatnama?
No, sir.
No, let the council remain present. I'm fixing it on another day.
Yes, your Lordship.
Heard Miss, what is your name?
R. Bormon.
R. Burman, submitting on behalf of Miss
And Soikia.
N. Sakya, who prays for an adjournment on the ground that the conducting council is not well. Also heard Mr.
A. Khan.
A. Khan appearing for respondent number,
All the respondents.
all the respondent who submits that this appeal has already been abated as
The petitioner has
the
expired.
appellant has expired.
The appellant, sir.
Considering the submissions made by councils, let this matter be listed again in orders column on 9th of August.
Yes, 9th of August.
9th of August.
My lord.
Obliged.
May I please, your Lordship? I beg to mention item number 11 of today hearing list here.
Yes.
But matter may be adjourned for 1 week, your Lordship. My senior is not well here.
What is your name?
A. Hussain, your Lordship.
Have you informed the other side?
No, your Lordship.
You have to inform. Otherwise, we'll pass orders when the matter is called for.
Your Lordship, I beg to mention one item for listing, your Lordship, for withdrawal.
No listing you have to mention before senior court.
Obliged.
May it please your Lordship. Lordship, this is a regular bail application. Elsa may be called for Lordship. The petitioner has been behind the bars for about 2 years, 5 months, 12 days today.
Heard Miss N. Sultana, learned counsel for the petitioner, also heard Mr. M. Deka, learned counsel for the Narcotic Control Bureau. Let the records of let the scan copy of the records of NDPS case number 180/2022 be called for from the trial court. The registry, as perusal of the same, is felt necessary for consideration of the instant bail application. Stop. The registry to take steps for requisitioning the scan copy. Let this matter be listed when
Any date, Lordship? Any possible date?
19th of August. 19th August.
Highly obliged. May it please your lordship. Your lordship may peruse office note dated 29/7/2024, your lordship. Office note states that your lordship unserved notice returned with postal remark partly deceased, your lordship. Whereas the service report states that notice was received by the wife and he was away due to personal grounds, your lordship.
Oh,
As regards respondent number 12, your lordship.
as regards respondent number
12, your lordship.
and as regards other respondents,
I'm appearing for respondent number 8, Lordship.
Respondent number 1 to 7 has already entered appearance, your lordship. And as regards respondent number 9, services completed as notice was received by the wife, your lordship. And as regards respondent number 10, notices were duly served. And as regards respondent number 11, your lordship, there was a direction for paper publication, your lordship. Although notices were given to the company, but your lordship, paper publication could not be done due to certain difficulties, your lordship. So my prayer is that your lordship, we may be given some more time.
paper publication in respect of respondent number,
11, your lordship. He is the owner of the vehicle insured by us.
and what will happen with 12?
Lordship,
What is your submission?
yes, your lordship, one report states that respondent number 2 has expired. Whereas the other report states that he was away due to personal grounds, your lordship. Two statements are there as regards respondent number 12.
Take fresh steps.
Yes, your lordship, we will take fresh steps.
Heard Miss P. Bothakur, learned counsel for the appellant, also heard Mr.
SP Sharma, Lordship.
S. P. Sharma,
Respondent number 8.
appearing for respondent number 8. On perusal of the office note dated 29/7/2024, it appears that the notices issued to respondent number 12 through registered post with AD has returned with endorsement within inverted comma party deceased returned to sender, whereas the notices issued to the same respondent through process server has returned with report that the notice has been received by the wife of the respondent as the husband is away on personal grounds. Considering the contradictory reports received in respect of respondent number 12, the appellant is directed to take fresh steps for issuance of notice to respondent number 12 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 12th of September 2024. As regards respondent number 11 is concerned, learned counsel for the appellant submits that they may be granted some more time to take steps for paper publication of the notices as directed by this court earlier. The prayer is allowed. The appellant shall take steps accordingly. The notice shall be returnable on 12th of September.
Lordship, date of appearance may be given any date in the
12
last week of October, Your Lordship. It will take some time for paper publication. And we will have to file the affidavit also, Your Lordship,
The
the last week of October.
the date of appearance of the respondent number 11 shall be given in the notice as 25th of October. Let this case be listed after 25th of October.
Bless.
Okay, Your Lordship.
Lordship, notice on respondent number 1, and we have been served, and we have been directed to take steps by paper publication, and we have made paper publication, and we have filed the affidavit enclosing the copy of the paper by which notice has been published for service of notice on 2 and 5.
What was the date mentioned in the notice?
Notice has been Doinik Assam, Doinik Nabaratna Prasanga on 22/6/2024.
No, no. What was the date of appearance?
1st of August.
First
Today.
of,
1st of August.
okay.
22/6.
No, in the notice, the date of appearance is 1st of August. So today is the date. He may appear. We'll fix it again. Heard Mr. S.K. Goswami, learned counsel for the, this is condonation of delay.
Lordship. Lordship, in this particular case, 2 MST cases been filed for death of one person, claiming both of them as a wife. One wife has get a compensation at Silset. Thereafter, another wife showing all other person as a claimant, file MST at Karimganj. MST case at Kasar has been settled, showing claimant's name in the initial stage is the earlier wife. And second MST case, second wife has filed saying that he is the first claimant. And all other also are included as a claimant. So this is a fraud committed by the claimant for getting 2 compensation for death of one person, 2 different tribunals.
Okay.
They will not come, Lordship, because the fraud has been committed.
Learned counsel for the applicant submits that the applicant has taken steps for issuance of notice through paper publication on respondent number 2 and 5 and
2 and 5, Lordship.
2 and 5 and has filed an affidavit of compliance in that respect, accompanied by the newspapers where the notice were published. On perusal of the affidavit on compliance as well as the attached newspaper, it appears that the date of appearance in the said notices is given as 1st of August 2024, that is today.
And it was published in the paper published in Karimganj because claimant are resident of Karimganj.
Okay. As the notices are duly served, duly published in the newspaper, and as the date of appearance is today only, let this matter be listed again after. On next week, we will fix a date. Listed on 8th,
So Lordship may record notices, service is complete, Lordship,
no, on 8th,
on that day.
on that day. On 8th of August.
God bless.
May please, Your Lordship. In this case, Lordship, as per this honorable court's order, we have published notice upon the in Assam Tribune and the Doinik Assam Upon respondent number 5, Lordship.
You have filed affidavit.
Affidavit, Lordship, but that affidavit is not in the record, Lordship.
Okay. Whether it has come. That has to come. What shall we do? We'll fix it some other day.
Yes, sir, some other day,
Heard
along with
Mr.
the affidavit.
Heard Mr. N.M. Datta, learned counsel for the applicant. Also heard Ms. P. Bhattacharya, learned counsel for respondent number
1 to 4.
1 to 4. Learned counsel for the applicant has submitted that in pursuant to the directions of this court, the applicant has taken steps for publication for issuance of notice on respondent number 5 through paper publication. And the notices are accordingly published in 2 newspapers, namely Assam Tribune and Dainik Assam. And it is also submitted that the applicant has filed an affidavit of compliance in that regard. However, same is not yet tagged with the case record. Stop. Therefore, registry is directed to list this matter again on 8th of August, along with the affidavit in compliance filed by the applicant.
Obliged, Lordship.
My lord, senior counsels of both these sides, my lord, are in court number 7, my lord. This matter may be taken after some time.
Why it has come in orders column?
This, as per the last order, my lord, it was fixed for hearing, my lord.
No, but it is not in hearing column.
After some time, my lord.
No, I'll take after some time, but
Maybe perhaps it has wrongly been listed on orders column. Lordship may take up the matter, my lord. Readings are completed, my
okay, after some time.
lord.
May I please, your lordship? Lordship, in this matter, on the last date, notices were complete and the date was fixed today, so as to enable the respondents to appear,
He is not appeared.
but they are not appearing, so this matter will be finally heard today, your lordship.
What is the matter? No, we will fix it for admission hearing.
Lordship.
It will proceed ex parte.
Yes, your lordship.
Heard Mr.
A Khan.
A. Khan, learned counsel. What is the matter?
Lordship, herein I'm the plaintiff and I filed a case against them, a suit, title suit. They filed a written statement and I would counterclaim. Now there was a delay on my part in filing the written statement against the counterclaim. That is not taken on record by the learned civil judge, senior division,
Why there was delay?
due to medical reasons, your lordship. I was suffering from jaundice. But the learned civil judge didn't take that into consideration. Lordship will find the impugned order at page 63, your lordship. And the operative part, your lordship, is at page 64.
What was the last order? Okay. Page,
64 is the operative part, your lordship. If I may read, your lordship.
yes, please read.
Considering the entire facts and circumstances, it appears that the prayer of the plaintiff's side to submit her written statement on counterclaim was already rejected on 13/12/2023 after the expiry of 40 days since 3/11/2023, which is the last date for submitting her written statement on counterclaim. The plaintiff has also failed to explain the cause of delay
How
in
many days were lapsed on 3/11/23?
3/11/23, which is the last date.
Last date means what were?
Means
Is the date of filing counterclaim?
since the day the filing
When the
the
counterclaim was filed?
counterclaim was filed, your lordship, on 23rd of August 2023.
So
On 3/11, it becomes 72 days. On 3/11/2023, it is 72 days.
what
So
is the limitation period for?
limitation period maximum is 90 days, your lordship.
Okay,
So this is one error that has been committed because 90 days is getting overed by 21st of November. 21st November 2023, stipulated 90 days. This is the directive period, not the mandatory period, Your Lordship.
okay,
May I further read, Your Lordship?
yes.
The plaintiff has also failed to explain the cause of delay in a proper manner, and it also appears that the last date for submission of written statement on counterclaim was 3/11/2023, and as per the plaintiff, she fell ill on 7/11/2023. Hence, it appears that she was fit to appear before the court on 3/11/2023.
What is your explanation?
Now, Your Lordship, I fell in on 7/11, that is true, and I have a medical certificate dated 9/11.
What
Now,
is-
Your Lordship, if Your Lordship may kindly come to page 48 for a moment. This is the order prior to this date. There's the order of this court on 13/12/2023. Page number 48, Your Lordship, annexure 6.
Yes,
May I read, Your Lordship?
yes.
Upon perusal of the case record, it appears that the counterclaim was received by the plaintiff side on 23rd August 2023. As such, the statutory period of 90 days is already over. Although on the last date, that is 3/11/2023, plaintiff was directed to submit their WS on counterclaim on the next date, that is today, even after the expiry of 90 days, but the plaintiff side has failed. So 13/12, I was given an opportunity to come on 13/12 and file my written statement. Now, the order of 10/5 is against this order because 13/12 was fixed for WS, not 3/11. 3/11 was not the last date, Your Lordship.
No, I am not getting you. That what it says, this order is of 13/12.
This order of 13/12,
Okay,
it makes a reference of what happened on 3rd/11. According to this order, 3rd/11, I should have submitted by WS
as 90 days were,
as 90 days. 90 days is already over on 13/12. By 13/12, 90 days is over. I was given a time to submit my written statement on 13/12 as per this order.
no,
It
this is the
says-
order of 13/12.
13/12, it says, although on last date, that is 3/11/2023, plaintiff was directed to submit their written statement on counterclaim on next date, that is today.
Okay,
That is 13/12 was the date fixed
okay, okay,
for written statement, not 3rd of November.
okay.
So this is one wrong finding, Your Lordship. And I fell in on 7th of November. So I couldn't appear on 13th of December. And my learned counsel, he appeared and moved a petition. And that was rejected. And after
Where
that,
is the 3/11 order?
3/11 order is not here, Your Lordship. That is not here, Your Lordship.
Then how will we know that what was ordered on 3/11?
Lordship, this order reflects what was done on 3rd/11. So,
But you should have annex 3/11 also.
Lordship, that is not here, Your Lordship. It's not on record. Anyways, 3rd/11 is not the last date, Your Lordship. If 90 days is considered, it will be over on 23rd, 21st. of
No,
11.
whether on 3/11 any court passed such an order directing you to file written statement on.
That I'll have to find out, Your Lordship, because as per my instruction, it was an oral submission made. No petition was given on that date, on 3rd/11 from the petitioner's side.
No, but it must have been reflected in the
In the
order.
order, yes,
order.
yes, Your Lordship.
And on that day, 3/13/12, whether your WS was ready?
No, Your
No.
Lordship, because I was ill, so I was not in a state to sign my affidavit. I signed my affidavit only on 21st of December, after I recovered from my illness.
Which is the order which you are impugning?
Lordship, I'm impugning this order, so this also, 13/12 also, and 10/5 also, both these orders. Because on 13/12, my prayer to grant me another day for filing my written statement was rejected.
Now, what is the stage of the trial?
Your Lordship, my niece and my sister, they have filed a petition under Order 1, Rule 10(2) for impleading them. So issues are not yet framed,
Issues are not
yet framed.
heard, Mr.
Mr. A.
A. Khan, learned counsel for the petitioner. No one has appeared for the respondent side, though the notices were duly served on them. Therefore, this court deems it proper to proceed ex parte against the respondent in this criminal revision petition, civil revision petitions. Stop. This application under Article 227 of the Constitution of India has been filed by the petitioner Srimati Bashanti Das, impugning the order dated 13/12/2023 as well as 10/5/2024, whereby the prayer of the petitioner for accepting the written statement against the counterclaim filed by the respondents was rejected on the ground that the period of 90 days for filing counterclaim is over. Learned counsel for the petitioner has submitted that the petitioner has filed a title suit for declaration of right title and interest and for delivery of khas possession against the respondents before the Court of Learned Civil Judge Senior Division Sirang. Stop. The said suit has been registered as title suit number 10/2023. Stop. It is submitted by learned counsel for the petitioner that in the said suit, the respondents appeared and filed their written statement on 23/8/2023. Along with the written statement, the respondent also filed counterclaim against the petitioner. The learned counsel for the petitioner has submitted that on 10/3 that by the order impugned in this revision petition, that is order dated on that. Now your written statement is ready.
It's already submitted. It's already on record, but the learned judge is not taking it into consideration. It's already in the file.
That on 10/5/2024, the petitioner filed his written statement against the counterclaim
Lordship,
with an application
Lordship.
to accept the same. However, the learned trial court refused to accept the same on the ground that
Sorry to interrupt your Lordship. Lordship, the written statement was filed on 1st February 2024. And it was rejected on 10/5.
okay. Learned counsel for the applicant petitioner, learned counsel for the petitioner has submitted that on 1st of February 2024, the petitioner had filed the counterclaim against the had filed the written statement against the counterclaim filed by the respondents. However, by order dated 10/5/2024, the learned trial court refused to accept the same on the ground that the petitioner was earlier, the application of the petitioner was earlier debarred from filing the written statement on the ground that he had failed to submit his written statement within the 90 days period it is also stated in the impugned order that as the counterclaim was received by the present petitioner on 23rd of August 2023, the statutory period for submission of counterclaim expired on 3/11/2023. Moreover, the petitioner, the trial court also did not accept the reason of ailment shown by the petitioner for not filing the written statement on 3/11/2023 as the medical documents, as the supporting medical documents submitted by the petitioners before the trial court showing his ailment showed that the petitioner fell ill only on 7/11/2023, whereas on 3/11/2023 she was well and in a condition to appear before the court for filing written statement. Hence, the prayer was rejected. Learned counsel for the petitioner has submitted that the trial court failed to take into consideration that on 3/11/2024, the petitioner / plaintiff was directed to submit her written statement on 13/12/2023. On that day, she was not well,
Suffering from jaundice.
as she was suffering from jaundice. Stop. I have considered the submissions made by learned counsel for the petitioner and have perused the materials available on record. On perusal of the order dated 13/12/2023, it appears that the order reflects that the petitioner plaintiff was directed to submit the written statement against the counterclaim on 13/12/2023, whereas on that day she was suffering from ailment, as the medical documents, supporting medical document shows that she suffered from ailment on 7/11/2023. Hence, the ground shown by the trial court for not accepting the written statement does not appear to be in consonance with the documents which are available on records. Stop. However, but you delayed, you filed on 2nd of February, on 1st of February. Why this much delay? You have to pay cost.
So after 13 December, the next date was 1st February.
You ought to have filed on 13
13
December.
December, Your Lordship, I was not well. I recovered only on 19th of December. As per the fitness certificate, the Lordship will find the fitness certificate at page 49.
Stop. Before last line or ago tarveta line, you know. On perusal of the fitness certificate submitted by this certificate you have deposited before the trial court.
Yes, Your Lordship. Yes, Your Lordship. The petition, Your Lordship will find the petition at page 56, annexure 9.
148 petition. Which petition?
148 petition.
Okay.
I filed it, and along with it, all the medical documents.
It also appears that the fitness certificate which the petitioner annexed along with the application before the trial court shows that the petitioner became fit to do her, petitioner is a female,
Yes, your lordship.
do her usual job on 19/12/23 only. In view of above, it appears that petitioner has a reasonable ground for not filing the affidavit within the time prescribed by the trial court. You have to pay cost to the,
Lordship. But your lordship, there was no deliberate delay.
but there was no wrong on the part of the, stop. Learned counsel for the petitioner has also submitted that the issues are yet to be framed in the pending title suit as who has filed impleadment petition
My sister and my niece.
as and that has not yet been decided
No. Next day is fixed for hearing on that.
as impleadment petitions have been filed by the sister and niece of the present petitioner before the trial court, which is fixed for consideration on the next date, that is
Next day, 16th of August.
16th of August. In view of the fact that, in view of the reasons mentioned herein above, as well as the fact that the issues are yet to be framed, the petitioner, the written statement filed against the counterclaim by the petitioner is allowed to be accepted by the trial court, subject to payment of costs of rupees 2,000 to the opposite parties respondent. With above observations, this revision petition is allowed and disposed of.
I'm grateful. I'm grateful, your lordship.
Item number 7.
No, please, your lordship. This I has been preferred, your lordship, to correct the name of the applicant petitioner, your lordship. At order, your lordship, dated 24/6/24, your lordship, at page number 8. Passed by your lordship.
Which I, okay,
Today I have filed one additional affidavit, your lordship. Your lordship, mistakenly I have inserted the name of the petitioner as Abdul Qasim, your lordship, instead of Abu Qasim, your lordship.
in the
Yes, lordship.
application.
Application, your lordship. And after that, your lordship, in the judgment, your lordship has directed the petitioner, your lordship, to appear before the trial court within 7 days from the date of the said order, your lordship. So that
That is disposed of.
disposed of, your lordship. The time has already been expired, your lordship. So for extension of period and for the correction of the
This heard Miss J. Borgohai,
G body.
and G. Bora, heard Miss G. Bora. Anything?
Because mistaken in the part, if her document is okay, then in that part.
Heard Miss G. Bora, learned counsel for the applicant. Also heard Mr. K. Bosho, learned additional public prosecutor. This interlocutory application has been filed by the applicant, praying for correction of the name of the, has been filed by the petitioner, praying for correction of the name of the accused petitioner in the cause title of anticipatory bail application number 501/2024, as well as in the order dated 24/6/2024 passed by this court in AB number 501/2024. Learned counsel for the petitioner has submitted that the name of the petitioner, the actual name of the petitioner is Abul Qasim, Abul Qasim,
Aadhaar card is there.
and in support of her submission, she has submitted the Aadhaar card as well as PAN card of the petitioner, where the name of the petitioner has been shown as Abul Qasim, ABUL, Abul Qasim. Stop. It is submitted that due to inadvertence and typographical mistakes, the name of the petitioner was reflected as Abdul Qasim in the AB anticipatory bail application number 501/2024, as well as in the order dated 24/6/2024, passed in the said anticipatory bail application. I have considered the submissions made by learned counsel for the petitioner, as well as perused the materials on record, including the supporting documents filed by the petitioner, which shows that the name of the petitioner is Abul Qasim and not Abdul Qasim. As it appears that the said mistake was a bona fide typographical mistake. Hence, the prayer of the petitioner is allowed, and the name of the petitioner be corrected in the cause title of AB case number 501 as Abul Qasim in place of Abdul Qasim, and it shall be, and in order dated 24/6/2024, the name, wherever the name Abdul Qasim is appearing, it shall be read as within inverted comma Abul Qasim. Stop. Learned counsel for the applicant has also submitted that in the order dated 24/6/2024, the petitioner was directed to appear before the trial court within 7 days of the date of the said order. However, due to the discrepancy in the name, the said time has already lapsed, and therefore she prays for extension of the time. Considering the submissions made by learned counsel for the petitioner, as well as considering the facts of this case, the petitioner is granted 15 more days from the date of this order to appear before the trial court in pursuant to the directions given by this court by order dated 24/6/2024 in AB case number 501/2024. With above observation, before Arveta, registry to make necessary corrections in the records of the courts regarding the name as directed herein before. This application is accordingly disposed of.
Much obliged.
Subsequently, my lord, newly engaged A. Rashid.
We'll take it after some time. Let Mr. Rashid come. পিছত মাতিম। Yes.
My lord, in this case, due to some compelling reason, my lord, the petitioner, he could not file his written statement within the period of prescribed period of 90 days, my lord. And my lord, the reason is that, my lord, the engaged counsel of the petitioner, my lord, he withdrawn due to some circumstances, and my lord, new set of counsel got only 2 weeks time to prepare and file the written statement.
Now, whether notices are served? for the-
Yes, on the last occasion, we were asked to take the justice service. And regarding service also, we have filed an affidavit. The affidavit is filed by advocate client. That is on record.
What?
And they are aware, because
Hmm.
yesterday this case was fixed before the law court, and they also submitted an application seeking adjournment to file PWs. So they were aware about the plaintiff is aware.
No, in the affidavit,
Affidavit, that notice of service is there.
but there is no signature of the,
Signature is there.
who is the respondent hospital?
Respondent hospital, it's some authority.
Okay.
So that seal is there. Seal and signature is there. That is also there. And advocate clerk of this,
Only one respondent.
only one declared. One respondent. The affidavit of service is filed by a advocate clerk. He himself went to serve.
But the date was fixed on 26/7.
On 26/7. This method did
Case
not
was-
reach. Did not reach.
Then how the respondent will know when to appear before the court, because they might have appeared on 26/7.
26/7, because thereafter again matter was listed on, my lord, even on thereafter last Tuesday also it was listed on the list. This is the order part yesterday.
What order? What order? You may read it.
In the lower court, civil court. We just have a typed copy of the order. We have produced the order of 26/7.
Oh, this. So this is within the knowledge of the,
Yes, yes, no. This seems to not to appear.
which order you are impugning in this revision petition?
Annexer
Okay.
18,
Page?
page 69. Parties are represented. Learned counsel for defendant has deposited cost of 1,000. Representative of plaintiff hospital is directed to remain personally present on the next date to receive the cost. Parish petition number so and so filed for defendant seeking further time 2 weeks to file its statement. at both sides on the petition page. Registered the petition submitting the statutory period for has already been expired. Record shows that on 7/2/2000, defendant entered into appearance. So this is important. On 7/2/24, defendant entered into and paid for time to file written statement. On the ground of shortage of time, the petition was allowed with a cost of 1,000. After that, the statutory period of which already expired. Today, the defendant once again paid the extension written of which cannot be permitted in view of the already expired on 31/1/24. And the defendant has already availed extension of time for filing written. As such, the petition so and so is rejected. Defendant is at liberty to participate in the suit without written statement as per law.
At what stage
It is
issues are,
no.
because
No,
no,
this date is fixed on 7/5/24. On that day, it was declared holiday due to Lok Sabha election. That order is there at page 71.
thereafter,
Thereafter, yesterday also they did not file PWs, and we sought adjournment.
now for what, at what stage the case is pending?
Cases, if the lordship takes up that order which I have placed for
Yes,
lordship, so it is for next date is for PWs and necessary order. Because there is only one defendant. Even issues were not framed. Because WS was not allowed to be filed. So no prejudice will be caused to my lord plaintiff if my lord defendant is allowed to file the.
no, why you have failed? What is the reason? What reason have you mentioned?
The reason is that the earlier engaged counsel, due to some personal difficulty at that point of time, he was out of station for several days. He withdrawn. And this defendant, he being a cardiothoracic surgeon, so he was out of station for about 4 days to attend one seminar at Bhubaneswar. And thereafter, after for about 1 week, he operated several heart patients, including some child. And post-operation, he was in the hospital round the clock. So he could not instruct his counsel to prepare the written statement. So that period of 2 weeks was too short, which was granted.
Okay, heard Mr. R. Bharali. S. Bharali. Learned counsel for the petitioner. None has appeared for the respondent side. It appears that the notices issued to the respondent side to the sole respondent was duly served through Dasti mode by the petitioner in pursuant to the directions of this court, and in support of the said fact, an affidavit of compliance has also been filed, annexed with a copy of notice wherein the seal of the respondent hospital along with signature of the receiving officer has been appended. As no one has appeared for respondent, this court deems it proper to hear this revision petition ex parte against the respondent. This application under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, has been filed by the applicant, impugning the order dated 20 2024, passed by learned Civil Judge Senior Division number 3. Civil Judge Senior Division number 3. Kamrup Metro in money suit number 87/2023. Where have you annexed that order? Whereby the petitioner on that day, whether you filed the written statement or you sought time
We sought time for 2 weeks.
for whereby the prayer of the petitioner for further time for filing written statement was rejected by the trial court on the ground that the statutory period for filing of the written statement had already expired on 31/1/2024, and after that you were allowed to file written statement with some cost.
Yes.
On that day also you failed.
The earlier council withdrawn.
Okay.
So only 2 weeks time, new set of council.
Stop.
got. And that was not enough.
Learned counsel for the petitioner has submitted that the petitioner is a what surgeon?
Cardiovascular. Vascular.
Cardiovascular surgeon, and he was engaged in some emergency operations
For a period of about 1 week.
for a period of about 1 week, for which he could not,
And also he was out of station for 4 days.
as well as he was out of station due to his professional engagement, and therefore he could not instruct his counsel. Instruct his counsel for filing written statement. Stop. Learned counsel for the petitioner has also submitted that the earlier engaged counsel of the petitioner, due to his personal difficulty, defaulted in appearing before there was a default. What?
He has given NOC. That was also just 2-3 days prior to the date fixed for filing WR. Only one counsel was there. That is at page 62.
He has withdrawn his wakalatnama, and
Thereafter, this present set of counsel got 2 weeks time.
and thereafter the petitioner engaged the present set of counsel, and very less time was available within bracket 2 weeks for instructing the newly engaged counsel, and therefore there was a delay in filing of the written statement. Learned counsel for the applicant has also submitted that the money suit number 87/23 was fixed yesterday, fixed yesterday, that is on 31/7/2024, before the trial court, for filing of evidence of the plaintiff side. However, the plaintiff sought for an adjournment which was allowed, and the
Plaintiff sought time for filing evidence.
plaintiff sought time for filing evidence which was allowed. It is also submitted by learned counsel for the petitioner that the counsel for the petitioner has already informed the trial court that regarding pendency of this civil revision petition before this court. And as the trial has not progressed, no prejudice would be caused to the respondent plaintiff if the petitioner is allowed to file his written statement before the trial court. When will you file? On the next date?
Next date is fixed on 25th of October. So within 1 month, we will, or within 2 weeks, that will be sufficient.
No, within 2 weeks, the plaintiff will not come on off date.
Yes, that is true. If it is allowed that on the next date fixed, we will file.
Stop. Considering the reasons shown for inability on the part of the petitioner to file the written statement in the time, within the time granted by the trial court, and considering the stage at which the trial is presently pending, this court is of considered opinion that for the ends of justice, the prayer of the petitioner may be allowed and he may be allowed to submit his written statement before the trial court on the next date fixed, that is on 25/10/2024 without fail, subject to payment of a cost of ₹2,000 to the respondent/plaintiff. With above observation, this revision petition is hereby disposed of, allowed and disposed of. Yeah.
This CLP has been filed under Article 7 of the Constitution. In this case, our injunction was vacated by the appellate court, first appellate court. The injunction was granted by the
No,
trial court.
they are not appearing.
They are not appearing. There is justice, order of justice services there, my lord, and it is last occasion your lordship pass order, and justice service the document is there, my lord. Every is also there.
Oh, yes. What is the matter?
So, my lord, without going through the matter, my lord, the value of the suit is 45 lakhs something, my lord. So the appeal against the CBA appeal against lie to the High Court, my lord. The district passed the order, my lord. So he has no jurisdiction to enter in his appeal, my lord.
You have that notification?
Yes, my lord. District valuation is 220 lakhs.
This ground you have taken in this petition also.
Yes. So, my lord, the impugned judgment is non-est, my lord. He has no jurisdiction, my lord.
Where is the mention that value of suit is?
Page 25, my lord. Page 25 is the plain mill. Milord, page 25 and also Milord, in para 32, page 40. For the purpose of jurisdiction and court fee, the suit for the declaration is valued at rupees 41,50,000. For recovery position is 4,74,000. So Milord, the value of the suit for the purpose of jurisdiction and the jurisdiction and pecuniary jurisdiction is fixed. Milord. There is a fixed 41,50,000. So on the basis of Milord,
This suit was filed before
before Milord, civil judge.
civil judge
Yes, Milord.
and thereafter
Thereafter, Milord, they preferred in the district. judge.
appeal before district judge. The appeal is,
Barred.
No.
Barred before the
it lies before the High Court. High
yes,
Court.
FAO. It will be FAO. So it is, Milord, this is the jurisdictional point. You're going to exercise under 226, Milord, supervisory power.
Heard Mr. P. S. Dekar, learned counsel
For the plaintiff appellant,
for the
plaintiff petitioner.
petitioner plaintiff. None has appeared for
Yes, Milord.
the respondent side. How many respondents are there? 5.
5.
Stop. It appears from record that by order dated 29/7/2024, this court has held that the notices issued to respondents were duly served. Stop. Hence, this court proposes to proceed ex parte against the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioner / plaintiff impugning the order dated 31/5/2024 passed in Miss Appeal number 1/2023 arising out of Miss J case number
8/2023.
No, what was the, where is the impugned order? At page?
Impugned order is at page, Milord, 117, Milord. Sorry, not 104. 104.
What was the order? It's set aside. Injunction was granted to you
Yes, Milord.
and it was set aside by
Set aside by the
the appellate court.
appellate court. Additional district justice also.
No, arising out of whereby the temporary injunction granted in favor of the present
Petition.
petitioner / plaintiff in Miss J case number 8/2023 in connection in title suit number 10/2023 was set aside by the Court of Learned Additional District Judge Sibsagar, and the said miss appeal was allowed. Stop. Learned counsel for the petitioner has submitted that the plaintiff petitioner had filed a title suit for what?
So, matlab injunction and
For
declaration.
mandatory injunction. Only for injunction,
No, my lord. Declaration and my lord, declaration also, my lord.
for declaration of right title and interest as well as for mandatory injunction. Before the Court of London, Civil Judge Sipsagar, which was registered as title suit number 10/2023. In the said suit, the petitioner plaintiff filed an application under Order 39, Rule 1 and 2, seeking temporary injunction against the respondents. Said Ms. J case was registered as Ms. J case number 8/2023. And by order dated, which order?
Page 78.
Order dated 21/3/2023. The trial court was pleased to grant. What was the grant?
Page 88, my lord.
Temporary injunction against the respondent. Grant temporary mandatory injunction.
Yes, ma'am.
Temporary mandatory injunction against the respondents, directing them to remove the locks of the shutters of shops described in Schedule C of the plaint. Stop. Learned counsel for the petitioner has submitted that the petitioner plaintiff had valued his or her suit at rupees 41,50,000 for the purpose of jurisdiction as well as for the purpose of the court fee. Stop. However, learned counsel for the petitioner has submitted that in spite of knowing the valuation of the suit, the respondent preferred the miscellaneous appeal before the Court of London Additional District Judge Sipsagar, whereas the Guwahati High Court by its whereas it is submitted that the Guwahati High Court by its notification number HC dot Roman 7-35/2020/6412/A dated 7/12/2021 has, while clarifying some points regarding the amendment in the Bengal, Agra and Assam Civil Codes within bracket Assam Amendment Act 2021 has clarified that the appeal from a decree/order of a civil judge shall lie to the district judge only where the value of the original suit is up to rupees 20 lakhs. And beyond that pecuniary value, the appeal shall lie before the High Court as as what?
Puja jurisdiction.
No, appeal shall lie to High Court.
Yes, ma'am.
What is the title of the appeal? Miscellaneous first appeal. First appeal against
First
order.
against order.
Stop. In the instant case, learned counsel for the petitioner has submitted that in instant case, the exercise of jurisdiction by the Court of Learned Additional District Judge Sibsagar while entertaining Miss Appeal number 1/2023 is in violation of the provisions of Bengal, Agra and Assam Civil Codes Act, Civil Codes within bracket Assam Amendment Act 2021, as well as the aforesaid notification issued by Guwahati High Court. Stop. I have considered the submissions made by learned counsel for the petitioner and have gone through the materials available on record, including the notification cited by learned counsel for the petitioner. It appears from the cause title of the plaint filed by the petitioner in title suit number 10/2023, as well as from paragraph number 32 of the said plaint, that the suit of the petitioner plaintiff was valued at rupees 41,50,000 for the purpose of jurisdiction as well as court fee. Hence, under the facts and circumstances, it appears that the appeal against the order dated titles in the Miss case, what was the order?
Impugn order, my lord.
In the trial court.
Trial court, my lord, it is, no, this to be original. 21/3/2023.
Appeal against order dated 21/3/2023 passed in Miss J case number 8/2023 by the Court of Learned Civil Judge Sibsagar would lie before this court and not before the District Judge / Additional District Judge Sibsagar. Hence, this court is of the view that as the impugn order has been passed by the Learned Court of Learned Additional District Judge Sibsagar in violation of the provisions of Bengal, Agra and Assam Civil Codes within bracket Assam Amendment Act 2021, as well as in violation of the notification dated 7/12/2021 referred herein above. It acted beyond jurisdiction, and on that count, the impugn order is hereby set aside. This civil revision petition is accordingly disposed of.
My lord, regarding the suit, my lord, suit for declaration of title, not title, my lord, declaration for the revocation of power of attorney and mandatory injunctions and recovery of cash position.
Suit for Agot Sharmila Agot Ase, suit for declaration, mandatory injunction and recovery of
Yes,
khas
yes.
possession. Oh. Yes, Mr. Rashid, what is this?
Regarding the civil litigation petition, but part from the respondent has expired in this case. So I have filed in this case IA. So IA number
Who has expired?
respondent number 2, 3, and 4. On
No,
seven-
first let us take up IA number 45.
My lord, yes.
Or which should we take?
And I'm telling you,
And IA number 45.
I number 45 million. 45 in this case, respondent 4 has expired. And
No,
there is
what for this 45 is?
45 million, this is for condition of delay, 298 days,
Condoning the delay of 290 days.
98. But order was that the legal years.
You are objecting.
No, my lord, earlier I am APR respondent number 4 subsequently dead. My lord, I would not appear before the dead person, my lord. This subsequently my learned fellow.
No, are you objecting to the condemnation of delay application?
Well, I am not in this IA case, my lord. However,
Okay, notices have to go to the
notice
legal
will-
heirs of
notice
number
will be
4.
issued, my lord, on legal heir of.
Then
the
you have to
respondent
issue
number 4.
notice to legal heirs of respondent number 4
My lord,
in this case.
yes. My lord, this as per order date.
Have
my
you
lord,
taken steps?
I have taken Mr. Miller, but there was, the office said something else.
What it says?
Respondent number says was not substituted, so notice could not send. So.
No, you have not named the, to
Yeah.
whom notice will go.
Respondent number 4, legal years. Only legal years and legal years name I have given Miller.
Where?
Not mentioned in the legal heir.
You have not mentioned the names of legal
There
heirs.
are one thing, say,
No, Mr. Rashid,
my lord.
in this condonation of delay application, which you have filed for condoning the delay in filing substitution petition,
My lord.
you have not mentioned the names of the heirs of respondent number 4. So to whom the notices will go?
Actually, I am sorry, my lord. That portion was left in my petition. So subsequently, I have filed another petition, my lord. That is in IA number 45, my lord. There on modification petition, my lord. And
IA number?
while
IA number?
in IA number 45/24, that case, when I filed IA, my lord, in this case.
No, this IA number 45 is before me.
Before there, then there is another IA, my lord, for modification. of
Which
that
IA?
order. Number will like in my office, my lord, that is there, that is in your lordship.
My lord, another, my lord, miscase file, my lord, I know 2178. My lord, is pray that, my lord, this earlier 45 application not mentioned in the legal heir.
Oh, it was.
IA number?
2178.
So many IAs.
Oh, that number I could not.
2178, my lord, pray, and another IA, the IA number 45, he could not mention in the, my lord, legal heir of the respondent number 4, subsequently filed this petition.
So, my lord, 2178, your lordship may kindly see, then kindly, my lord. Page 10, my lord. I have given all the name of the legal heirs, my lord. There, my lord.
But my lord, this 45 item, my opinion, my lord, may be implemented in the 45 for legal heir's name, my lord. Another.
Page 10, my lord, of 2178. Kindly see, my lord. I have given the name of legal heirs, paragraph 2, my lord, and that the names of the legal heirs of the respondent number 4 are as follows. 1, 2, 8, 7.
Okay, heard Mr. A. Rashid. A. Rashid, learned counsel for the applicant. This is in IA number 2178. 2178. This interlocutory application has been filed by the applicants praying for mentioning the names of the legal heirs of respondent number 4 in IA within bracket C number 45/2024, which the petitioners have filed for condoning the delay in filing substitution petition in CRP number 148/2017 on death of respondent number 4. Stop. Learned counsel for the applicant has submitted that due to inadvertence, the legal heirs of respondent number 4 were not mentioned in I number 45/2024. Stop. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. The names of legal heirs of respondent number 4, namely Nuraja Khatun, number 1, Roman 1, Firoza Khatun, Roman 2, Roman 3, Hanif Ali, Meriza Khatun, Aklima Khatun, Hamidul Khatun, Hamidul Islam, and Rashidul Islam be included in the cause title of interlocutory application number 45/2024 as respondent number 4 within bracket Roman 1 to respondent number 4 within bracket Roman 7. The registry shall make necessary corrections in IA number 445/2024 in pursuant to this order. This interlocutory application is accordingly disposed of.
And on prayer, I may be allowed to, after implement.
No, this will.
I'll send notice, my lord.
No. This will again be listed after list the continue in that the registry to list the IA number 45/2024 after making necessary corrections on 7th of August 2024. After registry will make corrections, thereafter we will pass orders for issuing notice.
In so many years, I could not place out. May I take the records for the timing just to place the materials? Not now, whenever the matter is called.
Yes.
Obliged.
None appears for the appellant on call. Let this matter be listed again after next week or in the next week. After a week on the date to be fixed by the registry.
May I please, your lordship? Matter may be adjourned for today, your lordship, as because my senior is on not well, your lordship.
But I have to file Ukalat number.
You have not
Normally,
filed.
The process he has not completed, my lord. Anyway, I have to file Ukalat number in view of the earlier order.
But it is fixed for hearing.
But I cannot say, my lord, Ukalat number yet not filed for reference number 1, 2, 3, 4,
Okay.
6 and 8.
Heard Mr.
A Hussain, your lordship.
A. Hussain, who prays for an adjournment on the ground that who is not well?
Vacation, your lordship. my senior.
Mr. B.K. Sen, who is the conducting counsel of this case, is not well. On the other hand, Mr.
DK Das.
D.K. Das submits that he is yet to file wakalatnama in for the respondent number
2, 3, 4, 5, 2, 3, 4, 6.
but
One is diagonal.
2, 3, 4, and 6.
5 and 7 I have appealed.
For 5 and 7?
5 and 7 we have filed.
Okay. When will you file wakalatnama?
It was filed on, my lord.
No. When will you file for the remaining?
My lord, the respondents herein, those who are yet not filed Wakalatnama, they are daughter of the, my lord, Basuna Pal, and she is living in various places, Diffu, Ulaghat, so some time may be required.
No, but this is a 2014 matter.
Yes.
What is the issue?
Issue is, my lord, allotment of a municipal shop room.
Who is in possession?
I am in possession.
File wakalatnama. How much time will you require?
2 weeks.
And 4 weeks time for filing the same. The prayer is allowed. The wakalatnama of the remaining respondent shall be filed by the counsel, Mr. D.K. Das, within 4 weeks from date of this order, list accordingly.
Good.
Which I'm praying that can be taken up next Wednesday on 7th, my lord. Some difficulties today, so 7th, my lord, if lordship allows.
My lord, I am the respondent plaintiff and I am the decree holder. For the past 6 years, I have not been able to enjoy the fruits of my decree.
Why are you praying for adjournment?
Well, my senior has some difficulties today, he's on legs in other court, my lord. I'm paying for day only, lordship may take up on Wednesday. 7th, my lord.
No, Wednesday we have other matters fixed.
Well, on lordship 9th, my lordship allows on 9th,
It
Friday.
has to be on a hearing day, either my lord.
It has to be on a hearing day.
6th or 8th, my lord.
Well, 6th and 8th.
My lord, lordship can see the order sheet each and every time they are taking.
No, lordship, last
adjournment.
number of.
Lordship can see the order sheet, my lord. How many times they have taken adjournment? It calls for a cost, my lord, in fact.
No. Your ground,
On 6th, my lord, lordship allows on 6th. 6th, the
okay.
hearing day.
The last chance, my lord, no, will make it clear, my lord.
No, his submission is that counsel is on legs in. What is the
It will take some more time and man senior to leave. That's why for a day only I'm checking adjournment for a day, my lord. Since
I think
he has asked for a hearing day, I'm praying for 6th, my lord.
heard Mr.
R.S. Mishra.
R.S. Mishra, learned counsel for the petitioner, also heard Mr.
J. Patwari.
J. Patwari, learned counsel for the respondent. Learned counsel for the petitioner has sought for an adjournment on the ground that conducting counsel, Mr.
PJ Saikian.
P.J. Sakya is on legs in a different court and therefore prays that this case may be listed on next Tuesday, that is 6th August 2024. The prayer is allowed. Let this matter be listed again on 6th August.
Obliged.
Who is appearing for only government?
No, I'm appearing for respondent 1 and 3.
Yes.
My lordship, how the time for my lord, machinery is coming, my lord.
I will start it, let them come, because I think government has to give a reply later on. I am the appellant.
They are the requiring.
They are the requiring department, that's a different level. They are the requiring department.
No,
We are aggrieved by
no,
the.
just a minute, let me decide.
I'm sorry, ma'am.
When, who will be appearing?
Mr. I am not senior advocate, my lord. She'll be appearing. He in Lexington court number 20, my lord.
Let them come.
They are requiring department, what they have to say, ma'am.
No, otherwise, if they miss your argument,
He can
if-
note down, he can note down.
is it okay? Okay,
Oh, yeah.
yes.
I have, I have prepared a note, my lord, for your lordship's convenience. I'll hand over to my learned friend also. Basically, we had a tea state. That tea state, your lordship can note down because it will be easier. I have made a list. So I'll just tell why are we before this honorable court.
Yes.
We had a tea state known as Beheting Tea State at Dibrugarh town.
Beheting.
Beheting Tea State at Dibrugarh town.
B.
I have made a note, my lord. Your lordship can read that. It will be easier.
Okay, now I will take my notes also.
Yes.
Yes.
So we had a tea state. Now, my lord, I'll just skip up and I'll give a list of where I'll start it. The government decided, AIDC decided to took the project for a particular gas cracker, for a gas cracker project.
Okay.
And they decide to acquire that land for a particular project. And accordingly, the land was measuring about 152 bighas, 4 katha, 4 lechas. This your lordship will kindly note down. It is item number 70. This is 3 of 2019, item number 70.
We are taking up first.
Kindly take, I made a note, it is almost same.
No, which should I take up? Which file?
Kindly take 70, item number 70.
3.
Yes. 3. Facts are similar. Land area is only different. Here land area is 152
152, 4 katha, 4 lecha.
Yes, 152 bighas, 4 katha, 4 lechas.
Yes.
So notification was issued under 4(1) of 1894 Act. And party was given opportunity for filing any objection. And declaration was under section 6 of the LA Act. And accordingly, my lord, the award was passed. Kindly note down the award 23/3/2007.
On 23/3/2007.
7. Now, there were some facts in between. Because 32 numbers of trespassers, my lord, they entered into this garden when they came to know that this property was going to be acquired by the government. So ultimately, 32 numbers of trespassers, they trespassed.
Okay.
And they were also citing reasons that Jirat has to be paid to them. And they were encroaching out of that 152 bighas, 4 kathas, 4 lechas, about 36 bighas, 1 katha and 15 lechas of land.
Okay.
Now, my lord, the award was passed by the Office of Deputy Commissioner, and they
Dibrugarh.
calculated Dibrugarh.
Okay.
Dibrugarh.
Yes.
The value of the Jirat, which was given to us in respect of 116 bighas, 2 kathas, 9 lechas. Because I told as your lordship that 36 bighas out of 152 bighas was that these encroachers, they encroached, and this land 36 bighas. So if we minus 152 with 36, it comes down to 116 bighas, 2 kathas, 9 lechas. So Jirat for tea bushes, shade trees and staff quarters. The amount was given to us amounting to 85 lakhs 77,898.
Okay.
And the Jirat, which was paid to the encroachers, is in respect of 36 bighas, 1 katha, 15 lechas of land. The compensation which was paid by to them was 1 crore 66 lakh 11,698.
This was paid to them.
I'm sorry, encroachers. They were
This was
encroachers.
paid to them.
It was paid to them.
Okay.
So out of 152 bighas, 4 kathas, 4 lechas of the land, which belongs to us. Some encroacher, they encroached these 100 out of that 152 bighas, 4 katha, 4 lechas, 36 bighas, 1 katha, 15 lechas of land. So they were sitting. They said we are also entitled to get Jirat. So accordingly, Jirat was paid to them. They said these are the tea bushes, these are the shades. There were also certain culverts, so that they said this should be paid to us. Accordingly, the authority has paid to them an amount of 1 crore 66 lakhs 11,698.
Okay.
This is one part. Another part, so far the land is concerned, the Deputy Commissioner paid 1 lakh per bigha. 1 lakh per bigha for 152 bighas, 4 kathas, 4 lechas of land. Which is amounting to 1 crore 58 lakhs 84,000.
This was paid to you.
It was paid to me. Now, my lord, when the encroachers, they encroach, some suit was filed. There was some injunction. Ultimately, due to some political pressure, we have to withdraw the injunction. So that is one of the positions. We have made a note of it. Your lordship will later on. It is everything in the note. Now, in the meantime, my lord, I'm cutting it short. In the meantime, we received that amount from the office of the Deputy Commissioner on protest.
Just a minute.
On protest. So, a reference, it was sent for reference before the district judge for a reference. Reference somebody film reference case.
Yes.
Reference. Case. Now, our reference in this case, your lordship kindly note down 43 of 2010. 43 of 2010. LA case number, Miss LA case number.
In LA Appeal 3.
43 of 2010. There are two LA cases. In 3, in
But
this
in the
case,
cause title, you have mentioned 44 of 2010. In the cause title of LA Appeal number 3 of 19.
let- but my note is at 43 of 2010 in appeal number LA appeal number 3 of 2019.
But you have mentioned it in the cause title.
Post title post title here 43 an appeal under section 54 of the Land Acquisition Act arising
No,
out
it
of
is-
reference judgment order dated 21/3/2016.
In item number 16, that is 40.
Item number 16, it is 44, and item number 17, it is 43.
43 is in case of LA case number 2. LA case number 2 in the cause title 43 is mentioned. Otherwise, there will be mixture.
No, it's
43 lots.
but I think the bilik ke likha hai.
You go through the records.
Record to say.
এনেকে দিব এনেকে খোলা খোলা দিব
That's it. That's the file.
Oh, that is mistake. In 2, that is mistake. 244.
Now, where is the mistake? In your submission or in the?
In 2. In LA Appeal 2, LA case number is 44. What
I
to have
think
been
there is
44.
some mistake here.
Then whether mistake is in the pleadings also?
Readings, no, because
If there is mistake, it has to be amended.
no, Lord, there is no mistake because certified copy has been. Because into.
Otherwise, your submission and it will not tally.
17, 17. You be there in the 47.
11 appeal number 44 or 11. Next file to 70. 43 has to be. Oh, Amar Gandhi. We have done mistake. Amar mistake. is it? Here is correct, Lordship. Our number is different.
Okay.
44.
It's a big mistake.
We done.
We made a mistake actually.
Here 44.
So the records are okay.
Yes, sir.
Yes.
44.
Yes.
Miss L case number 44.
Yes.
So, my lord, we institute a reference under section 18 of the Act to the learned district judge Dibrugarh, my lord. It's under 1890, old Act 1894. And during our course of the deliberation, and evidence was also adduced by showing that the once sale deed, saying that the value of the land, the market value is 6 lakhs. That was placed before the learned reference court. Now, during the pendency of the reference, my lord, the original claimant died, and according to present, appellants were substituted.
Yes.
And on 21/3/2016, the reference court, my lord, allowed the reference to the extent that from rupees 1 lakh, so far as the land value is concerned, which was given by the Office of Deputy Commissioner, that was enhanced to rupees 3 lakhs per bigha.
Okay.
But the reference court said, whatever the amount, 3 lakhs you will get it, but that should minus the Ziraat amount which you have got. Already it has been paid to you. Minus the Ziraat amount, which your lordship has noted, somewhere about 85 lakhs. 85 lakhs odd amount. That should be minus from that 3 lakhs rupees. 1 lakh to
But
3
3
lakhs
lakh
which
was
there.
assessed for land only.
Yes.
But the learned reference code said that no. What we are doing it, we are enhancing from 1 lakh to 3 lakhs. Even our claim was 6 lakhs on the basis of the sale deed and the market value. Now I'll show there is evidence to show, but the learned reference code relied that no, we are paying you 3 lakhs, but to the extent, whatever the Ziraat amount you have got, that has to be deducted. Now he merged both the components. He Ziraat and the land, he merged both the components. Now that will be the issue whether both the components can be added or not.
Okay.
That will be one issue. That will be one proposition whether the both components can be merged or not. Then, my lord, this is A, my lord. This is A. The 1 lakh to 3 lakhs, it is increased, but it was, the Girard amount was merged with the land, value of the land.
Okay.
Now that proposition, whether it can be merged or it has to be treated separately. Now number B, my lord. Now additional amount of 1,40,000 for land measuring 1 bigha 2 kathas of severed land. That has been given 1/3.
Additional amount of 1 lakh?
40,000. Measuring 1 bigha 2 kathas of severed land.
What
That too
land?
also.
What land?
But this type of land has been remained after taking the land, a 5 feet by 100 feet long remain. So that land.
That
has to
was
be
not calculated. That was additional amount was given
by the reference.
by the reference code.
For how much the,
Uh,
how measuring how much?
Measuring 1 bigha 2 kathas.
1/3.
And what he has done, my lord, reference code, that is 1/3 of the compensation per bigha has been paid
1/3 of the compensation?
per bigha. What we are
For
saying,
this land.
for this land, what we are saying, you should have given the full amount. As you have given the 1/3 amount, he has not calculated the full amount.
No, no, I am not getting this point.
My lord, this 1,40,000
In respect of 1 bigha, 2 kathas of land,
kathas,
1/3
1/3 value has been given, 1/3
1/3 value of what?
of
1 bigha
1 bigha 2 kathas.
per bigha 3 lakh.
Per bigha,
At the rate of 1 lakh
1
40,000.
lakh to 3 lakhs he has enhanced. 1
Yes.
lakh to 3 lakhs. So what our contention, if it is 1 bigha, the amount should have
At
been
the
given
same rate
same rate. Now you have not given the same rate. 1/3 of that amount. was
of that
given.
rate
Yes.
in respect of other land.
Yes. Right.
Okay. What is this severed land?
Severed land, my lord,
Type of land. After taking the land, we are remaining a land of 5 feet wide and 100 something feet land
In between or outside?
outside. But as per the act, that has to be given to the, because that is useless. Because 5 feet.
That
by-
is SEVERED.
Yes.
Yes,
SEVERED.
Okay.
We'll find it out and I'll tell what is the exact, what is the severed land. Now, my lord, this is number B, whether, my lord, the rate which was given by the reference code which was enhanced from 1 lakh to 3 lakhs, whether 1/3 could have been given by the reference code. Or whether he could have maintained that same rate which he has increased from 1 lakh to 3 lakhs.
1,40,000.
So our is 4,20,000 we should have got, 4,20,000. Our
For
calculation,
this 1 bigha, 2 kathas
yes,
of
yes.
land.
Our at the rate of, if
3
you
lakhs.
enhance from 100 to 1 lakh to 3 lakhs, and you have given 3 lakhs, so the rate which in respect of 1 bigha 2 kathas, it would have come to 4,20,000 as per our calculation. But what the learned reference court has said, 1/3, that is 1,40,000 has been paid.
So it said that 1/3 of the other land,
Yes.
rate for other land,
Yes.
rate for acquired land,
Yes.
1/3 of
1/3 of,
3 lakhs.
yes.
Okay, okay, understood.
But I have to find out why this severed land, why that particular 1/3 of the amount was paid.
What was the logic?
What was the logic behind? I'm just giving a aerial view of the case, my lord. This will take some time. It is not that it will not be over because there are 2 dates and making it very clear to your lordship.
Okay, no issue.
Very clear to your lordship. Let us, because this will require some time.
No,
That's
when-
why I'm giving a aerial view so that they can note down. I will go in details. This will take some time and severed, what is severed land, for what purpose it was given, my lord. Now, my lord, the C, this is B. A, your lordship has noted. B, your lordship has noted. Now, C. Interest under section 28 at the rate 9% per annum, which was not given by the collector, it was given by the reference court on the amount of compensation awarded by the court, less Girard paid. That is the excess amount that has been paid by the reference court. And that too, your lordship will kindly note down, this was paid with effect from the date of taking the possession up to 1 year. And thereafter at the rate 15% per annum till payment into court. As per section. And this has been this has been paid as per section 28. So lordship will kindly note down award under section 28 as per the Land Acquisition 1894 was paid by the reference court at the rate of 9% per annum. Up to 1 year from the date of taking possession, which was not paid by the collector. And thereafter, at the rate of 15% per annum till payment into court. My lord, this is as per the statute. This is laid down under section 28 of the Act. So he has looked into reference code section 28, which was not given by the collector. It was given by the reference code. The statutory norms, it has to be paid
Okay, what is the issue in
under
this
section
case?
28.
This was directed by the
Reference
district judge court.
Yes, reference code.
Yes, reference court.
Yes.
Then
Now, my lord will kindly see D. I will go into details.
no,
I'll-
no, with regard to point number C,
Yes.
what is the issue? The reference code directed that interest at the rate of 9% per annum minus the Girard already paid
Yes.
till 1 year, till the date of payment up till 1 year thereafter.
Thereafter
15% per annum.
per annum till payment into the code.
That was the order of the reference code.
Reference code.
Now, are you agreed with this? Or
No, this is not agreed.
this is just a statement of
Yes,
fact?
statement. Statement
Oh,
of
okay.
fact, and this is not agreed.
Okay.
We are not agreed. This is given to us. Your lordship kindly note down, this is, we are not agreed by that.
Okay.
This is, we will not praise this.
You have no grievance against this.
No. Only what grievance we have
Girard was
here
deducted.
is minus that Girard.
85 lakhs.
85 lakhs has been minus. Less Girard paid.
That is the grievance.
Yes.
Yes.
And D, he awarded interest under section 34 at the rate of 9% on the compensation awarded by the collector 34 not paid money, not paid.
You are able to be an interest when the amount of not paid or deposit or not taken.
Now, what is the difference between 28 and
See
30?
34 of the Act I just read it and I will show the provision later on. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon on the rate of 9% per annum from date of time of so taking possession until it shall have been so paid or deposited.
Now, what is the difference between 38 and 24? 28 and 34.
34,
28 regarding the excess compensation.
the is regarding, 28 is in regard to excess compensation. Excess.
Only to the extent which was made during reference.
Yes.
Yes.
Okay, okay.
And 34 is compulsory.
Is only
34 is compulsory ma'am, under the act. So these are the,
Sudhir,
yes.
Land Acquisition Act 1894.
The review code is review allowed. My lord, there was some arithmetical error in the judgment. So my lord, we file a review application before the reference court. That is under section 114, read with order 47, rule 1 and section 151. Praying for review of the judgment. Judgment is 21/3/2016. And accordingly, on 16/5/2016, my lord, review was allowed. And by awarding territory solusium at the rate of 30%. Which was not paid, I think, earlier. A reference of nothing.
Okay.
Oh, this is a position. So we are aggrieved and we are before this on the court. Once, my lord.
So your main grievance is first that land and Jirat component was merged.
Yes.
Second, that instead of full rate, 1/3 rate was
Right.
given for the severed land.
Yes.
Third, that
Jirat,
the
yes.
interest was not paid on, the Jirat component was subtracted from the
Yes. Right.
interest paid.
Yes.
And fourth, 34, there is no grievance.
34, my lord.
34, where there is arithmetical error.
30, no, award interest up to under section 34.
There is no issue.
No, if it is enhanced
By this.
by this code, then automatically
This is statutory.
statutory.
Now, why you are before this court only for those three grievances or any other relief?
These three grievance. These are three grievances.
Then the under 34 automatically it will
Yes,
increase.
it will rise. Yes.
Okay.
Yes. If your lordship is satisfied.
Okay.
That's the whole. Now, my lord, for your
And
lordship.
regarding review application,
Review-
which was
Yes,
which was allowed that arithmetical error,
yes.
what was added?
This is my lord solution. Added 30% in terms of 23(2) of the act.
So
Huh?
statutory provision is there for
Yes,
self-
territory solution, 30%.
Now it is good, earlier 34.
Earlier under the old act, it was 30%. Now I think under the new act it is 100%.
No.
So it was under the old act. So 30%. So that is a sanctuary. So that was allowed. Now, my lord,
have
kindly
to
see the note.
You have to explain to me
No, I'll
what is,
now kindly see the note. Then I will go to a judgment of that note. I no trouble with the list of dates already. That list of dates is a detailed list of dates has been given. Kindly see the grounds of appeal. That will be more easier. Then I will take to your lordship. Lordship got it? Grounds of appeal. Down. I made a
no
note.
grounds of appeal in the note.
Grounds of
in-
appeal
in
here
your
in the
note.
present case.
Yes. it's-
Note.
Yes.
So your lordship will get a view.
In LA3, okay.
Yes, your lordship will get a view thereafter. What contention we have taken. Well, now my lord will kindly see, though enhanced the value of the land from 1 lakh to 3 lakhs per vigor, but has not enhanced the Jirat surface compensation.
Yes, that you have.
Now,
checked.
club both the Jirat surface compensation as well as land acquisition compensation, which is against the law. The Jirat compensation, land compare two different components, which cannot be clubbed together.
Okay.
But both the head must be calculated separately. Now this is important. Next, fail to appreciate the exhibit 44, 45, 46 and 47 properly. Inasmuch, white exhibit 47, the claimant appellant sold a contiguous plot of land to deed and registered Dibrugarh University, in which the value of the same was shown as 6 lakhs per vigor. The evidence of comparable sale instances as exhibit, white exhibit number 47, which clearly establishes a higher market value of land than what has been awarded has to be considered. So we have, my lord, exhibited SLD, which shows that it is amounted 6 lakhs market value, but that was not considered by the learned reference code. Because reference code said that we are considering only the whatever it is in the register in the sale permission. Because normally a rate is that is a zonal rate. So on the basis of the zonal rate, and one of the exhibit of the government where it shows that it is 3 lakhs. So basing on this zonal rate as well as the one of the exhibit which was produced before the court saying this is what the government rate, 3 lakhs.
Okay.
And our contention is that it should be on the basis of the market value. And on the basis of that, we have produced a sale deed, that is exhibit number 47, which was not considered by the learned reference code. So whatever contention is that it is the market value was not taken into consideration. And there are some certain other aspect also which we have taken. The proximity we have taken.
Yes.
It is near railway station. All these points I will show it, my lord. That was not taken into consideration by the learned reference code while fixing the land value. Now, my lord, next, we'll go into details, my lord. I just showing it, my lord, what are the grounds we have taken. Fail to appreciate the admitted fact that the next, my lord, that DC White the award dated 23/3/2007 awarded an amount of 85,77,898 to the appellant at Jirat for land measuring 116 bighas,
No,
2
no.
kathas.
Which note you are reading?
So that note, which your lordship is.
Again, there is a mistake because here it is 67 lakhs, 62,000. So you have a.
Other case. The
No.
next one will be the for this.
No, but you have not corrected it because I'm taking up land acquisition appeal number 3. You have to make corrections
Yes, yes.
because it is in 2.
Yes, two.
Sudeep, itu দিয়ক শুনতে ভেরিফাই এনেকে দিব It holds the
As
flow.
senior, I remember when I started somewhere in 85, there was a very senior, Your Lordship, I don't know whether Your Lordship remember one very legendary of our High Court, J.P. Bhattacharya.
I have not seen him, heard about him.
Hard. He's all his juniors, I think I was E.K. Goswami, then Mr. Rojango, all his juniors, about 11, 12. So I had the opportunity of going to his place and one brief a matter which belonged to P.K. Goswami, and he was out of it. He said, you go and brief it. Then he taught me one thing. When you start in the court, and in the meantime, these things happen, my lord. When you start before the court, then everything should be perfect. There should not be
Yes.
any distraction to the judge.
Yes, otherwise flow.
Whatever you argued from the first, and in between there is a distraction between the judge and lawyer, everything goes.
Yes.
You may argue the best of best. In between, there is a distraction that whatever you argue, that is gone.
Yes, but I am taking notes.
This is the problem, man.
Yes.
The earlier also, my lord, which my if 85 onwards, 85, I am saying one. I am telling your lordship, all the judges on 85, I started, all the judges used to take note. But there was a lot of time because number of cases were very less at that relevant time. But note, they used to take note, individual note. Even a list of date was mandatory. The hearing matter list of date was mandatory. One has to give a list of dates. That was mandatory. List of dates.
Okay.
Even if we have now synopsis. At that time, there was no synopsis. There was civil rule before any writ petition, if not writ petition, the civil rule before a division bench. Thereafter, they changed into writ petition before single bench. Aggrieved by that order, you can go for division bench. But in the hearing, list of hearing, when hearing the matter comes up, list of dates is mandatory. Otherwise, they will not take up the matter. They will make a note of their own, but list of date has to be there.
Because it helps.
It helps.
Yes.
Now, my lord,
85 lakh 77,000.
85 lakh 77,892, the appellant at Jirat for land measuring 116 bighas, 2 quarter 9 less. Whereas my friend has come, Mr. Allah. That's why I'm inquiring.
I'm the BCPL here, but he has got no grievance against me, my lord. I'm just a formal party, my lord, to be present with your lordships, my lord.
That's why I said, my
That's why. And also there is an order by this honorable court in earlier occasions, my lord, regarding that appeal, my lord. Why we are not a necessary party. The lordship can have a look at those two orders, my lord. Otherwise, they don't have any submissions.
Okay. Okay.
They don't have any grievance against me, my lord. Lordship can find here, my lord.
Earlier PCPL has filed appeal. You can check it.
It was heard earlier also.
No, we came against that passed by the district judge, my lord. Against that, my lord, what happened? Deputy Commissioner sent a letter to us as if we are a party to pay the money, my lord. So came before the honorable court. The ultimate additional advocate general said, no, we are not the party to be. We are only the beneficiary. The land was acquired by the government and they given us to the factory, that Lepet Kata, my lord. Deputy, my lord. We only made the factory there, my lord. Industry there.
You are this Brahmaputra crackers.
Yes. Nothing. We have got nothing to do with my lord.
Nothing to do.
And that has been clarified by this.
I told you, material instruction is more important. Material instruction.
God bless my lord. It's almost 1 o'clock.
We'll continue after lunch.
Yes. I will touch the factual part is down. And thereafter, just there is some one matter, so you will receive any date. I will, 1 o'clock, 2 o'clock, we'll continue with this appeal. What grounds we have taken. Thereafter, you will kindly. I
It
have.
will spill over to
Yes,
summer.
spill.
We have fixed other matters on it.
Then next Tuesday, after Thursday, next Tuesday.
Then let it be on in the third week of August,
Madam,
2020.
2020.
Or date should be fixed by the registry. I will only mention the week.
Madam, Your Lordship.
On 20, your lordship.
20.
28.
Item number 8. On request of learned counsel for both the sides, let this matter be listed on 28th of August.
Lordship, I have a similar prayer with regard to item number 18, your lordship.
18.
18, 1/8, lordship. The matter may kindly be adjourned, your lordship, for today. The consent has been obtained from the others.
And also we can have Mr.
H. Gurag,
H. Gurag, has done counsel for the
appellant, your lordship.
appellant. Request for an adjournment. With consent from the counsel for the other side. The prayer is allowed. Let this matter be listed
After a week, your lordship.
after 2 weeks on date to fix.
Deeply obliged.
Why not, can it be spill over and take it for another date, my lord? Because my learned friend has also come all along from Calcutta. So, my lord, any date which is
In
convenient.
this case,
No, other
In some
case.
other case.
Yes, item number 16, there's a bit confusion because your lordship has said that something was wrong in the calculation. Actually, your lordship is taking item number 16. Your lordship is 17. In fact, it is item number 16.
Yes.
Yes, sir. So if it is not inconvenient, my lord, so can it be on like on 13, subject to your lordship availability in the bench? We don't know. If
Then-
it Parthas, then
then I'll not keep it as part of.
let's see.
13th I'll be there.
I'm sorry, my lord,
I'll be there on 13th,
13.
but I don't know the rest of it.
Okay. Or my
Suggest
lord,
you make
next week or 5th
Or 13th, okay, I'm
Or-
keeping
or
it part.
5th.
I'm keeping it part.
Yes, because your lordship has heard this much. 13.
Heard. Mr. D. K. Das. Learned Senior Counsel, assisted by Mr. S. Deka, Learned Counsel for the appellants. Also heard Mr. K. Bhattacharya.
This date is.
It's Bhattacharya. Hey, Bhattacharya, Learned Counsel for state respondents. As well as Mr.
And for response number 2, my
Forgot your name.
M. Nath.
Yes, yes, you are there. Mr. M. Nath appearing for respondent number
2, my lord.
2,
Assisted by Mr. A. Bhattacharya, my lord.
assisted by Mr.
A. Bhattacharya.
Then senior counsel assisted by Mr. A. Bhattacharya. The hearing remained inconclusive. Yes, let this matter be listed again on 13th of August as
Yes.
part of.
I'm deeply obvious.
I'm appealing for the appellant in this case.
No, I'm for the respondent, two, my lord, opposing, my lord, this.
In fact, my lord, there are some developments in the case in the sense that on the last occasion, my lord, when the matter was heard,
Yes, what is the?
yeah, I may indicate one more thing, my lord. This is an appeal under order 43 rule 1R against an order passed by the learned trial court, whereby our application for modification and or vacation of the temporary ex parte temporary injunction order that was passed. For modification that we filed, that was rejected. As against that, we have come here. The basic reason for rejection is not really on merit, but on the ground that earlier the honorable court had passed an order keeping the further proceedings of the suit in abeyance.
Now, what is the matter? What is the issue?
It's a suit, my lord. Suit is for declaration that some shares are existing in the name of the plaintiff and defendant number 2 in the
Suit for declaration.
suit for declaration that the plaintiff is the sole owner of the shares which are lying in the name of both the plaintiff as well as defendant number 2 in the demat account of HDFC in the HDFC Bank, which is also included as defendant number 1 in the suit. Now, initially, my lord, when the suit was filed, along with that, an application was filed under order 39 rule 1 and 2, praying for an injunction basically restraining defendant number 2, who is the joint holder, from selling or transferring the shares. That was the prayer. And in that case, my lord, an ad interim ex parte temporary injunction in the form of a status quo was passed. And before the matter could be finally heard, the plaintiff expired. Now, although the plaintiff expired, apart from defendant number 2, although the plaintiff has another daughter, but she is not contesting. The daughter to contest Quran. Nobody came up for substitution. And nobody came up for substitution. She is the
No, I missed the track.
my lord, plaintiff expired during the pendency of the suit before the temporary injunction matter could be finally heard.
Who is the plaintiff?
Plaintiff is my lord,
Before this court now, the defendant has come.
pardon me.
Well, the plaintiff was my lord, Sir Hemendra Prasad Barua, my lord, who had filed a suit claiming, or rather, my lord, saying that the shares which was originally purchased by him with his money and my lord was transferred to the joint account of him and his daughter, my lord, belongs to him. This is my lord, the original suit which was filed. There's an order of my lord, status quo with regard to the shares which was passed. Then my lord, he passed
now
away.
you may-
Plaintiff expired.
Plaintiff expired.
Plaintiff expired, but
there's
the
a will.
plaintiff could
No,
not be
let him.
Yes.
Plaintiff expired during the pendency of the suit and before the temporary injunction matter could be finally heard and decided.
But there was a status quo. order.
Status quo order was there.
The shares are in your name.
Shares are jointly in the name of the plaintiff and defendant number 2. The appellant before your lordship.
Defendant number 2 is your
Is the appellant before your lordship. Is the daughter of plaintiff.
daughter of the plaintiff.
Plaintiff.
Okay.
Now she is the defendant. She is a contesting defendant, so she cannot be substituted in place of the plaintiff.
Okay. Then
Thereafter, my lord, one application was filed for substitution of the plaintiff by a person who claims to be the executor of a will. Their will was executed according to him by the plaintiff. He is the executor, he is the beneficiary, and he filed an application for
will of the plaintiff.
Plaintiff executed the will.
Will.
Now, for
Who is-
getting
who is the
probate of the
plaintiff?
will, as suit has been filed, now it's a suit since there is a contest before the Calcutta High Court
Okay.
on the original side. And that is still pending, probate has not been granted. And as the lordship is aware, under the law,
Who filed that suit?
the executor,
Who is the,
who is the applicant for substitution
before? okay,
before the trial court.
Trial court.
No.
What is his name?
He is, what is his name?
Somnath Chatterjee.
So, Somnath Chatterjee, my lord.
Okay.
He filed an application for substitution. We opposed it. Now, ultimately, the court has passed an order that since probate has not been granted, I am not passing the order for substitution. As a result, the matter will remain in abeyance.
Okay. It abated.
The application for substitution as well as the suit will remain are kept in abeyance. That was the order. This order was passed way back, my lord. Is here? 23/12/2013. Yes. By the trial court. Thereafter, my lord, this order was put to challenge in before this honorable court by way of a revision petition. Both the parties challenged this order, my lord. There were two revision petitions, and by an order passed on 14/11/2014, both the revision petitions were dismissed. No appeal was taken before the Supreme Court against this order. So order has attained finality.
What was by order dated 23/12/2013? The substitution petition was kept in abeyance.
As well as the suit.
Suit also.
Yes, because there is no plaintiff to pursue the suit. My lord.
But whether suit get abated or not after.
And that is another question, my lord. Whether suit abatement of subsequently an application was filed for a direction or for an order that suit has abated in the meantime. That was dismissed. And against that, a revision application was filed before some report that was also dismissed. We went to the Supreme Court. But then before the Supreme Court, somehow we withdrew the SLP. Dismissed.
Now, what is the status of this?
Dismissed on
suit?
withdrawal. Dismissed on withdrawal.
Now, what is the status of this suit in which this?
That suit is lying like that. Now, my lord, what has happened? That there is a issue, my lord, that although we are joint holder of the shares in respect of which the suit has been filed, we have been denied of all the benefits a shareholder has normally in a company. As a result, my lord, because my lord, the injunction was paid by the plaintiff for the purpose of restraining defendant number 2 from selling the shares, not for depriving her of the benefit of a shareholder. Page 44, Lordship may kindly have a look at it. Page 44 of the memo of appeal.
Yes.
Lordship has got my page 44.
Yes.
But possibly Lordship need not take notes because today the matter cannot be disposed. There is a reason, but I'm coming to that. I'm coming to that. This prayer at page 44 will show, my lord, what was the.
Heard earlier on the last.
It was heard. It was heard, my lord. What has happened, my lord, because of the order passed by the trial court keeping the suit in abeyance, and which was ultimately affirmed by the Supreme Court. Even this Supreme Court in the appeal has said that there may be some difficulty in passing any order on merit. And then, my lord, question came as to whether parties should pray for modification of the order passed by Honorable Justice Indira Shah in both the revision petitions. At that stage, my learned friend was present. He has also said that he is also in favor of filing an appropriate application. And I also expressed on behalf of my client.
Revision against that 20.
No, my lord, seeking review of the order, because that is
23.
possibly I'm saying, that is because there are judgments to show that even in a case where this kind of order of keeping the suit in abeyance is passed for some orders which do not further the proceedings of the suit, but for if a prayer is made for a modification of any order passed as an interlocutory order, the court can proceed. There are authorities, madam. Anyway, my lord, this Honorable Court, Honorable Justice Devashri Barua, while hearing the matter, indicated that unless some avenue is given, possibly there may be some difficulty in passing a final order on this, in this appeal on merit. Then, my lord, from my side, my lord, I suggested that I am going to file an application.
One query. When the appellant died,
My lord,
on which date appellant?
appellant, my lord. Appellant died on
No, not appellant,
31/7/2013.
Plaintiff.
31/7/2013, my lord.
31/7/2013.
My lord.
So when no substitution was done,
Normally, it should get abated.
by operation of law, it gets abated.
Absolutely,
For that,
absolutely.
no order is required. That is my understanding. You.
Yes.
So, my lord, absolutely correct. But here, my lord, we made an application for substitution. And this point has also been urged by them. And my lord, up to the Supreme Court, they have not succeeded. Because I'm not at fault. I made an application, my lord, for the purpose of substitution within, my lord, that period. Within that period. Because I'm the executor to the will. I have to, my lord, make an application for substitution. My lord knows under the Succession Act, I'm the legal representative. But the court thought that unless probate is obtained, my lord, of the will, my lord, the substitution cannot happen. And that is, my lord, what was affirmed, my lord, in the civil revision preferred by both of us, my lord, in 2014.
Yes.
Until then, my lord, it's been pending. And what has happened, my lord, in the probate application, all the other heirs have given, my lord, consent. Except, my lord, for my learned friend's client, everyone has given consent. My lord, the daughter-in-law, the other daughter. So, in the probate application, they're taking time. That's, my lord, what we have put in the affidavit as well.
No, I am concerned. Now, in this revision, this FAO, you have preferred appeal against which order?
Against an order recently passed
Status
on an application filed by me for a modification of or vacation of the order passed.
Status quo order.
Yes.
No, that wasn't, my lord, that wasn't the application, my lord. I'll just give application page.
No, let me understand. Let me understand.
Absolutely, madam.
My query is that status quo order was passed in a miscase
My lord.
in the suit.
My lord.
Yes.
If the status of suit is not clear, whether it is abated or it is still there.
Yes.
So, it is clear, my lord, it has not abated. It is not abated. That order is there, my lord, of this court
As your
itself.
lordship has indicated, by operation of law, it has abated. It is another thing that the
Unless
application.
there is a restoration,
Yes,
but by operation of law.
it is abated.
My lord, it cannot, my lord, because I made an application. That application is pending.
No, it will be restored. Abatement will be set
No, my lord,
aside.
my lord, it can only abate, my lord, when that period has passed.
Yes.
That period has not passed because I made that application before.
No, but
My lord, on 31st July, my lord, the plaintiff has died. On, my lord, 12th August, I made the application in 2013, my lord, for the purpose of substitution. My lord, if I may just show, my lord, one order.
My lord, substitution petition filed by them has remained in abeyance now. And a revision application preferred by both the parties against that order has been dismissed. So the order keeping the suit in abeyance still remains. And the substitution petition.
Lord, if I may try and, my lord.
Okay. So it will abate only if no application is there. So if there is an application.
I'm grateful.
It will not affect.
That's they have filed the application, but then application has been, has not,
No, but
that
the law
application is kept in abeyance.
It will abate only if no application is
No
made.
application is filed.
Okay. Now what happened?
Now, my lord, today it has come up because on the last occasion, there was an indication from the honorable court that some avenue has to be there for enabling the court to pass an order. Then from my side, my lord, I suggested that I am going to file an application seeking review of the order passed earlier, affirming the order
Which
of,
order?
my lord,
Order dated 23/12.
last order, I mean, it will go to last order. It is the last order. My lord, there was no indication as such in the order. Nothing is reflected, but then
Look,
I made a submission.
I have not made any sub. I want Malad the appeal to be dismissed because according to me, Malad, the appeal Malad does not lie.
Okay.
And Malad, this is the second round, Malad, again, Malad, coming up from the same issue. First round, Malad, they came, they were not successful, Malad. I'll show that order, Malad, of Malad 26 July, Malad 21. Then, Malad, they went up to the Honorable Supreme Court. There also, Malad, SLP dismissed. My learned friend says withdrawn. No, it was dismissed. It's all, Malad, annexed.
No, but first let me hear Mr. Majumdar.
Yes, Malad. That's what Malad, I was in, Malad.
My lord, today, why I am
Now
indicating,
the status of suit is that it is not abated,
yes.
then we may proceed.
Yes, my suit is, I'm not saying that suit is abated because this,
No, that was my.
what, my lord, what I'm saying is, my lord, in this case, on the last action, there was a clear indication by the honorable court, and I prayed for time for filing an application seeking a review of the order passed by Honorable Justice Indra Shah.
Which order?
Page 117.
Page
117.
Page 117, madam.
In the revision,
This is the order, my lord, whereby two revision petitions filed against the order, common order passed by the learned trial court, whereby the, my lord, substitution petition was kept in abeyance.
that
This
is
along
order
with the
dated
suit.
23/12.
13/11/2014.
Which order?
Thir-
Order
thir-
dated?
13/11,
2014. Page 1.
no, no. Kept in abeyance 23/12/2013.
This this filing this revision petition, which order was challenged?
Page 23, 2013.
23rd December, my lord,
That I am-
23rd December 2013.
3rd December 2023.
No, 2013.
Sorry, 2013.
Yes.
That order was challenged in this revision petition.
Two revisions.
Two
Two revisions, one by them and other by us.
And the revision petitions were dismissed,
Dismissed.
keeping the 23rd.
Upholding the order passed by the trial court, keeping the suit in abeyance as
Yes.
well as the subsequent
Yes.
petition.
So suit remains in abeyance.
My lord, in fact, what has happened on the last section, there was a discussion on the question of law as to what kind of order should have been passed by the trial court. And the law is very clear. Law says that until and unless the probate is granted, decree cannot be passed by the trial court, but the suit can proceed and substitution can also be allowed. This was the submission made by my learned friend. And I also submitted that since the order is not correct, I'll file an application seeking review of the order. And my learned friend approved, yes.
No,
yes,
I did not.
Yes, I was present.
No,
So
no.
what-
How is the review possible after all this?
What I am suggesting today is, I am praying for it because my my learned friend's client is from the USA. He is residing there. She couldn't come for the purpose of filing the review application. I am praying for some time so that I can file the review application. This was the indication by me on the last unit before the court below.
Review of the order dated 13/11/2014.
Yes. This is the order, my lord. 13/11/2014. Because this honorable court was clearly of the view that that order was factually not correct, legally was not correct. And unless a review, something is done, review applications, I indicated, my lord, I prayed for some time for filing a review application, and this honorable court granted me some time.
Yes.
That is the position. And that's why I'm asking for time, my lord.
Praying for an
So that,
extra-
my lord, my lordship,
Malad, may I just,
one more, sir.
after my learned friend finishes, Malad, I'll take Malad just 10 minutes to Malad come to this appeal.
Yes, my lord, once more submission. I pray that along with that review application, this appeal may be taken up for final disposal. That is my prayer.
But review application is yet to be filed.
Yes, yet to be. That's what I'm paying for time because he's not here, man. She's not in India. That's why I'm paying for just one more opportunity.
Yes.
My lord, this appeal, my lord, is against an order dated, my lord, 3rd.
No, before you submit on merits,
I'm sorry.
what is your response to his prayer for an adjournment on the ground that they are going to file a review application?
My lord, if and when they file a review application, my lord, that will take its own course. This appeal has nothing to do with the review petition. Because this appeal is, my lord, from an order of 3rd August 2023, by which the learned judge, and in my submission, my lord, correctly has said that in view of the suit being in abeyance, the application being in abeyance, I am also putting your application till that is heard.
That modification of status quo order.
Yes, and not modification. They wanted a recall. Kindly look at.
Where is the impugned order?
The impugned order, will find at page 159. And from 2014, they have not thought fit to file a review or prefer any further action on the basis of that order. Kindly see 159. It's the last annexure to their stay petition.
159 is not there. Yes, 159 is there.
Kindly see scene petition 1307-1553 filed by the learned counsel for the petitioner with a prayer to defer the passing of order showing cause that he may be heard on the law point. Perusal of the order sheet itself is clear that I have already heard both the sides on law point. Video order dated 17 July. There is no cogent reason to allow the petitioner's prayer today hearing on law point afresh. Petition stands are rejected. Then defendant number 2 filed a petition under Order 39 Rule 4 with a prayer to set aside ex parte ad interim injunction order dated 30th August showing cause of change in circumstance matches that the sole plaintiff died on 31st July and the deceased legal heirs are not interested in pursuing the suit as they have not taken any steps to substitute themselves in place of deceased plaintiff. Now this is incorrect. Is not correct. Defendant number 2 contend that the ex parte injunction is causing hardship to her Sansa. Then enjoying a share in a public listed company belonging to the family which accounts for 25% of the paid up share capital of defendant 1 company, for which she has prayed for setting aside the order dated 13th August. Somnath Chatterjee for the plaintiff filed written objection, contending that the petition is misconceived and the estate of the deceased plaintiff devolved upon him as is the sole executor under the last registered will and testament dated 19 September 2012 of the plaintiff who died on 31st July during the pendency of TS 41 of 12. It is contended that probate proceedings in respect of the said will is pending before the Honorable Calcutta High Court being TS 21 of 2016, converted into a contentious cause PLA 316 of 2015 and renumbered as TS 27. It is also contended that he filed an application on 12th August for substituting his name in place of deceased plaintiff, but the said application along with TS 41 2012 is kept in abeyance. Vide order dated 23rd December 2013 by observing that the said substitution petition will be heard only after the executor has obtained and produced the probate of the registered will of the deceased. The civil division petition being 47 of 14 and 97 of 14 filed by him and the defendant number 2 respectively was dismissed vide a common order dated 14 November 2014 by the Honorable Guwahati High Court. Denying the defendant number 2's allegations, it is contended that as substitution petition is pending disposal, the question of setting aside the order dated 13th August is not tenable and thus prayed for dismissal of this case. But both sides Perusia. Plaintiff Hemendra Prasad Bodua filed TS 41 of 2012 for declaration, injunction, other reliefs. Perusal of the civil division of miscellaneous, court records of miscellaneous J case 27 of 12 arising out of 27 TS 41 of 12 reveals that both the parties were directed to maintain status quo in respect of equity shares lying with defendant number 3 in DP Sansach till hearing disposal of the injunction petition. Sole plaintiff died on 31st July and Somnath Chatterjee filed a petition to substitute his name in place of deceased plaintiff on 3rd September. Substitution petition itself was filed well within the period of limitation as envisaged under Article 120 of the Limitation Act. Our Honorable Guwahati High Court video order dated 17 November, this should be 13 November, in CRP 47-14 and CRP 97-14 has declined to interfere with this court's order dated 23rd December, which has kept the substitution petition filed by Somnath Chatterjee in abeyance till the disposal of the probate of the will proceeding before the Honorable Calcutta High Court. In that view of the matter and for all the reasons as mentioned above, and as the substitution petition TS 41/2012 is kept in abeyance with a Honorable Guwahati High Court's order, hence propriety demands that the present miscellaneous case in connection with 27/2012 arising ought to be kept in abeyance till disposal of probate suit before the Honorable Calcutta High Court. Then my lord, inform both sides. Now, my lord, this is the impugned order. I just want to show another order. My lord, kindly, my lord, bear with me. Kindly come to, my lord, the reply. From the same suit, they had filed another application saying, my lord, the suit has abated. Kindly, my lord, see what this High Court held. And, my lord, what the Supreme Court thereafter, my lord, dismissed. Kindly, my lord, just take that. My lord, in the reply, just, my lord, kindly take this order.
How does it?
Page-
How does it? How does it? How does?
My lord,
it
page
evaluate
213. Let me just give
the
me
appeal?
2 minutes. My lord, kindly come to 26 July 2021 order.
No, no, Mr. What is your name? Mr.
My lord, I am, my lord,
Chakravarti.
Ratnanko Banerjee, my lord.
Mr. Banerjee.
Yes, my lord.
My query was whether do you concede to his prayer for adjournment or not?
No, my lord, I am, my
You are
lord,
not conceding.
I'm not considering, I'm saying the appeal is not maintainable.
Then
Appeal should be
let him
dismissed.
make his submissions.
Yes, my lord, appeal should be, my lord, dismissed.
Then we are not adjourning it.
My lord, Lordship may kindly have a look at the last one.
We'll hear and dispose of the matter.
Yes, kindly.
Now, Lordship may kindly see the last order passed by the Honorable Court on 20th of June, 2024.
Yes.
Upon hearing the learned counsel appearing on behalf of the parties, this
Further-
court finds that a further hearing would be required in the instant appeal according to the matter is be listed and so and so. So further hearing in furtherance of an argument made by both the parties was that, my lord.
No.
That, my lord, I am repeating my submissions.
No,
My
but
learned friend
he-
approve of that.
No, no, I'm
principle
not.
of law.
How can I?
I'm
Very
making.
well, you can put what you want to put
I'm
in my
making
mouth.
my fresh submission, madam. Madam, both the parties agreed on that day that.
But he's not
Madam,
conceding.
No, no, why should I agree?
Madam,
My lord, if,
What?
my lord, it falls from the court that whether a review application, my learned friend wants to file a
Madam,
review
let me
application,
make
up to
my-
him.
Madam, let me make-
I'm not saying why should I file a
Madam,
review
let me make
application.
my submission. What I'm saying is not clear. I have not
Very well.
already submitted. On principle, both the parties agreed the law is very clear that if a probate is, if a will is executed by the plaintiff in favor of someone bequeathing his property, he can always be substituted. If my learned friend today saying that I do not want any substitution so that the injunction matter cannot be heard and he is enjoying the benefit of the injunction order, that is another thing. They are enjoying, I am against the temporary injunction order because I am suffering. They are enjoying it. Now, when they say that yes, substitution should have been done in view of the principle of law laid down by the Honorable Supreme Court. Of course, my lord, the decree can be passed unless the probate is granted. That was your submission on the last occasion, and that is the position of law. Now, when you were denied substitution, you challenged it up to this Honorable Court. Thereafter, you also did not challenge it. Why? Why do you not want substitution? You have not challenged this before the Supreme Court because you are happy, because you are enjoying the temporary injunction order, ex parte injunction order. That is the reason.
No, before Supreme Court, you said that matter was withdrawn by you. You went against it.
No, that's
dismissed.
a different application, madam, not against this. Nobody preferred any, nobody went to Supreme Court against this order.
Binding on us.
It is binding on us. My learned friend's client wants to be bound by the order by which their substitution petition was rejected.
Not rejected.
Kept in abeyance,
Rejected.
kept in abeyance, yes, kept in
Don't say
abeyance,
that, please.
kept in abeyance. You are not moving any further because you are enjoying the temporary injunction.
I can't.
It cannot remain forever, my lord. My lord, this,
So now
why I indicated the
assuming-
last order, my lord.
Assuming that the probate disposal of probate case takes time,
Yes.
does it mean that status quo will remain till that period?
For indefinite period. That is the
That
reason.
is the effect of the order.
Yes.
Effect of the order is I am suffering, they are enjoying.
No, there is no suffering. My learned friend has never got exercise any right regard to the shares. It was always in the name of the father.
My
As
lord,
first
it was-
holder,
No, my lord, my learned friend is wrong.
no, no, I'm
The
not
very
wrong.
purpose of filing the suit is that they apprehended that after the death of the father, shares were lying in the joint name of the father and daughter for whatever reason. And after the death of the father, the shares will come to the individual demat account
No,
of the
no, absolutely not.
defendant. It is their standing.
Absolutely not.
It is their standing. Let me show from the petition, my lord. Lordship may kindly come to one particular page of the inaction petition.
No, Mr. Majumdar. Mr. Majumdar. The plea that you are taking that I am going to file a review application.
Yes, review or recall petition.
Review.
That, my lord, this was indicated by this honorable court. And
but
when I
that is-
prayed for time,
But that is not.
not indicated, but in the presence of my learned friend, I made that
He
prayer.
is not. He's denying that.
No, no, no. Then we'll have to go to the video.
But there is no question. How, my lord, can I, my lord, say that let us agree and set aside that order?
My query is
My lord.
that can we, your prayer is that you are going to file a review application. Therefore,
Recall application.
this should be heard
Along with that.
along with.
Along with that. But that this was the indication, this was the, I made the prayer, this honorable court granted that prayer. Today I am making just a prayer for asking for some more time so that I can file the application which the honorable court agreed to grant me time on the last occasion.
No, where does it say?
And if my learned friend
No,
says,
now you will suffer if it is
Well,
deferred, because status quo is
yes, yes, my
there
lord.
on your application.
My lord, I'm on the question because I've also not been heard. In the court below, I've also not been heard so far as my lord, the merits is concerned. My learned friend is assuming that the status quo order would be varied. No. The status quo order will continue till my lord, the suit is heard. I don't know why my learned friend assumes
I'm not
that my lord,
assuming that.
as soon as he goes to the court, my
I'm
lord,
on-
he will my lord, get a status
I'm
quo
on the
order
page
varied.
that the matter may be heard on merit. It was not.
My lord,
heard
we
on-
also both tried, my lord, 2014 order, which my lord has seen. 2014 order, my lord, dismisses both our my lord, revision petitions. He's also been happy with that. He's also my lord, not gone up to the Honorable Supreme Court from that order. And not only that, I wanted to show an earlier order where my lord, he tried the same thing. And my lord, what this High Court has said, my lord, this Honorable Court has said, with regard to his earlier application, my lord, 26 July 2021.
That is for abatement, man.
Yes, it says that a misleading application. That's what my lord, the
Alright.
finding is.
How does it have any bearing on this merit of this
Because
appeal, man?
what is happening, my lord, he is my lord, resisting. My lord, my learned friend's client is resisting the probate application, taking time there. Doesn't want the probate, my lord, to go through.
Why my learned friend is assuming that once a probate petition is filed, probate will be granted? And
At
I
least
not
let us
object?
try out the probate
Why should I
petition.
not object? Why he is presuming that?
I am not
everything
assuming
is-
anything.
Then-
Let the probate be
then
dismissed then. You
Why are you
win.
repeatedly saying that?
No substitution.
NOC, I have not given. I will not.
Not
I am-
NOC, my lord,
I
you
am
can't.
objecting to the
My
grant
lord,
of.
it can't be that my learned friend would also play, my lord, one court against the other. Here he comes and says, you decide this. It is kept hanging. There, my lord, he will oppose hearing of the probate application. I'm not in the question, my
I'm
lord.
entitled to oppose, my lord.
Not hearing. Not hearing.
I'm
I'm only on the question, my lord, that suit also has to proceed. We have annexed the High Court orders, my lord, where is asked for adjournment.
My lord, my only submission is, my lord.
When are you going to file review application?
It is my consent. 2 weeks time, my lord.
My lord, my submission is,
She
my
is
lord, the
from the
review has nothing to do with this.
Absolutely, my lord, it has. Because this honorable court clearly indicates, my lord,
No, my lord.
my lord, this honorable court,
My
we
lord.
can go to the video, my lord. This honorable court has indicated that unless you show
My
me
lord.
some avenue, I am finding some difficulty in passing
Yes,
the
that's
order.
right. That's right.
And
My lord,
that is-
one court can
and
give liberty
thereafter-
to file a
and
review, my lord,
thereafter
of a
this-
2014 order.
Thereafter, if this honorable court has, my lord, just one submission. If this honorable court has granted me time for filing an application for recall of that order, so that this appeal can be taken up on merit. Today, I am asking for some more time for filing that application. Why should this honorable court not grant me, my lord?
No, I'm sorry, my lord.
Another
I'm sorry, my lord. I'm not, my lord. That's not, perhaps, my lord, that's not the understanding. Because otherwise, my lord, the court, my lord, has only recorded upon hearing learned counsel. This court find that a further hearing would be required in the instant appeal.
My lord, that was my.
Because I'm insisting, my lord, that this
my
appeal, my lord, should be dismissed.
In course of deliberation, my lord, on merit, I can argue, but since last time this honorable court granted me time for filing an application for recall, I am praying for time. Otherwise, I would not have asked for.
My lord, that is
on
not-
merit, my lord, I have my own case.
So kindly, my lord, let that, my lord, be heard. I also want to show, my lord,
I'm
what the,
only
how the
paying
court
for
has reacted on the last occasion you came up from
I'm
that suit.
paying for 2 weeks' time. Lordship will kindly grant me 2 weeks' time so that I can file the recall application.
No, otherwise, the law is that even an executor who has filed a probate application
Yes.
may be substituted.
Yes, my lord, I conceded
My
to
lord,
that, my lord. That is the law.
I can also, that's not the point. My lord, if I say anything again, he'll say you have agreed. My lord, that may be the law, but my lord, this court has decided the law saying that no, this, and relying on, my lord, a Supreme Court decision.
No.
Bina Bani.
Now,
Against the
what
Supreme Court
I'm-
judgment.
Now a status quo is in operation.
Yes.
If we hear this matter after 2 weeks, it will continue to operate. Status quo would continue to operate.
Yes, yes, my lord.
You will be prejudiced in no manner.
My lord, I fully bow down to that, but I don't want these two matters to be tagged because according to me, my lord, this has nothing to do with this review.
That we will
That your lordship will decide at the
decide later on. But the urgency of hearing, because this application,
Yes, they are enjoying the status quo.
because he approached the trial court for modification of the
Yes.
status quo order,
Recalling of the order.
which was not setting aside of the
Yes.
order, which was kept in abeyance.
Yes.
So it has not affected you in
No.
any manner.
No.
So even if it is 2 weeks' time is granted, you will not be affected.
My lord, I'm only, my lord, on the question that, my lord, it should not be linked. Because I'm a little surprised, my lord, that my learned friend says I also agree to a review
No,
petition.
we cannot link it now.
Yes.
Because it is not yet
That will
filed.
be decided in the
Yes.
course of time. But
is not yet
let me
filed.
file. I am only saying that let me file the application. How? Why my learned friend is scared of that?
No, no, not scared. Why should I be scared of anything? It's an order of, my lord, the honorable court.
Mr.
Where's the question of being scared?
D. Majumdar, learned senior counsel assisted by Mr. B. Kaushik. Also heard Mr. R. Banerjee, learned senior counsel assisted by Mr.
Sharma, my lord, DN Sharma.
D. N. Sharma. Learned counsel for the appellant submitted that the appellant that this matter was heard on 26/2024. However, during the course of hearing, no, learned counsel for the learned counsel for the appellant has submitted that the there is 23 order dated 23/12/2020. 2013.
I'm sorry.
This
My lord, page, no. Lord, which, I'm sorry, my lord, I didn't.
Order dated 23/12/2018.
My lord, that is page 183. That's one of the first order, my lord. Then the revisional application order, my lord, is 2014, November, 14 November.
At page
183 of my reply, my lord, will find that.
and the revisional court's order,
14,
Revision is 14 November 2014.
at which page?
My lord, at page 203, if my lord is looking at, my lord, our reply.
117, man.
Appeal also, my lord, at 117.
Submitted that the appellant intends to file a review application for reviewing the
Recall application. Recall. Lordship may write review, it's recall.
review/recall application for recalling of the order dated 13/11/2014 in civil division petition number 47/2014 as same has bearing in the instant case also.
Lordship may kindly mention the two numbers of two revision because this is their revision. Ours is 97 for 2014. Madam. Two revision petitions were disposed of by
Civil revision petition
97 of
number
2014.
47/2014 as well as
97.
Civil revision petition number 97/2014,
Mine.
which were disposed of by common order.
Mine. Yes.
Common order dated 13/11/2014, whereby this court refused to interfere in the order dated 23/12/2013,
Right.
passed in title suit number 41 slash. What is the title suit number?
41 of 2012.
41/2012, pending in the court of learned civil judge Jorhat. Learned counsel submits that as the applicant stays abroad in United States of America, he needs
2 weeks.
at least 2 weeks' time for filing the said review application, and prays for listing this matter after 2 weeks. Considering the, you have any submission?
Well, I am opposing, Malad, that this, Malad, has any link. That's, Malad, my submission.
Learned counsel, learned senior counsel for the respondent opposes the prayer, has opposed the prayer for deferring the matter as he submits that the outcome of the proposed review application would not have, has no bearing
Yes.
on the instant revision petition.
Instant appeal, Malad. This is an appeal.
Instant appeal, stop. Stop. However, considering the fact that by order dated 23/12/2013, passed in title suit number 41/2012, the application for substitution of the name of the respondent number three as the legal representative of the deceased plaintiff was kept in abeyance only because of this fact that the probate application filed by the respondent number 3 before the court, which court?
Malad, the Calcutta High Court, Malad.
Before Calcutta High Court is still pending. Stop. Whereas there is no dispute at bar that when a probate application is filed, the executor has right to be substituted in
Perhaps, Malad, that is not, Malad,
That-
there's the learned
No,
judges
that
have.
observation I am not in line to cut it. In view of the above, in view of the above facts, this court deems it proper to defer the matter for 2 weeks as prayed for by the learned counsel for the appellants. Accordingly, release this matter after 2 weeks.
That
Malad, is it
fixed date in the.
Possible, Malad, the 29th? 29th?
No,
Malad?
after
Let
2
this
weeks, it
matter be
becomes
listed
16th.
again
madam.
on-
Let it be 16th.
Malad, 16, Malad, we have some.
They are coming from outstation.
29th, Malad, if the other matters, Malad, fixed, Malad, it could be on the 29th.
Same date becomes equal. Let it be 28th then, madam, 28th.
Is it okay?
একদিন আগে এসে যাবেন।
Where?
না না এই করতে আমার না প্রবলেম অন্য করে যেত না আপনি দেখতে পারেন।
You suggested it.
28th.
Let it be 28th man. We have got
28th of
another matter on
August.
29.
29th my lord, I was praying my lord would have been 29th এখন না আপনি তো রিভিউ অ্যাপ্লিকেশন করবেন তাই এটা
Let
শোনানি
it be
হবে না
28th man. I've got some difficulty because I have to go to different courts. Today I failed to go to attend to that.
But they are coming from outstation.
It's good. Man, if he stays here for 2
কাইন্ডলি
days.
কিপ 29th এ রাখুন সুবিধা হবে আমার আবার 27th সুপ্রিম কোর্ট করে আসতে হবে If it could be kept on the 29th, I'm sure my lord, the review application also will not be disposed of, my lord, if they file.
There is another matter where both of us are contesting against each other. That is fixed on 29th. How long that will take? No one knows.
Kindly put it on 29th, কোনো অসুবিধা আবার তো টাইম করে দেব
29th of August.
29th, agreed.
29th of
All right.
August.
ওই আজকের মতোই হবে আর কি। হ্যাঁ টাইমিং
না না ওখানে আর কোথাও হবে তাই তো আপনি তো এটা অলরেডি গ্রেটফুল
Lordship, letter is still going on court number 10. Kindly fix it.
I would not pressurize her.
Yeah,
She may fix it.
Definitely.
Only this matter is pending since long.
Third, Miss, what is your name?
M. Bora,
Third, Miss M. Bora.
on behalf of SP Chaudhary.
On behalf, submitting on behalf of Mr. S.K.
SP Chaudhary.
S.P. Chaudhary, learned counsel for the appellant. Also on Mr. S.S. Day,
Yes, Bunny.
sorry, S. Vanik. Learned counsel for the
Sole respondent.
sole respondent. Learned counsel for the appellant has prayed for an adjournment on the ground that the conducting counsel, Mr. S.P. Chaudhary, is on legs in some other court. Considering the submissions, the prayer is allowed. Let this matter be listed. When do you want?
At the earliest,
After 2 weeks on a date to be
could it
fixed.
be prior to that? Miller?
Fix it.
Any date, Miller?
You suggested it,
Lordship 16.
not 16,
Not 60.
21st. No, sorry,
No, it will be prior, madam.
20, hearing
20.
date.
20th hearing.
Let this case be listed on 20th of August. Yes.
The appellant is absent and the respondent mother. But
We'll defer it for one. What should we do?
I don't.
What should we do? Dismiss it for default or defer it?
They have taken time for last 2.5 years, madam.
Yes.
And my.
You're for the appellant. What is,
The conducting counsel is suffering from serious ill health. My lord has done 2 weeks time.
this is item number 19.
Madam, next Monday it should be fixed, and if your lordship is pleased to. Yeah, for the one time.
Third, miss, what is your name?
Madam,
What is your name?
PJ Sahawalam.
E.J. Sahavala, learned counsel for the appellant. Who prays for an adjourn, also Mr. B.C. Das, learned counsel for the respondent. Learned counsel for the appellant prays for an adjournment on the ground that the conducting counsel for the appellant is not well. Considering the ground, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged me. 2 weeks.
no one date may be fixed, but the.
Registry will fix the date. It is difficult for me.
Date may be fixed, madam. Otherwise it will remain for months together.
22nd of August. Let this matter be listed on 22nd of August.
22nd of August.
Okay, okay.
Well, I'm for the respondent. Appellant's counsel was present here, just I have sent for them. It's a long pending matter, my lord. If it can be taken up.
Let him come. I'm ready to hear.
Yes,
Who is the counsel?
R.D. Mazumdar.
Okay, I have seen.
She was there. She was there. Just she has gone outside. Hey, I'll tell them.
What should we do? We'll take up some other matter. If
Next item is also where I am appearing.
next item.
Or your lordship can take up item 21. My correct 21?
My senior is coming in 2 minutes.
2 minutes.
2 minutes, my lord. There wasn't that time.
Okay.
In both the cases, my lord, item 20.
21,
22, 21, 22. 21, 22.
By single case, both the case should be 21 and 20.
But let the council come.
Yes, they are.
Twenty-three matter.
23.
Twenty-three. None appears for. the-
My senior
Yes.
agent next matter may kindly possible for the.
Just a minute. In 23 or 24?
24.
24. 23, none appears for the petitioner on call. Let the matter be listed after 2 weeks. The interim order shall continue till next day, 24th day. Yes.
May I please, lordship?
Lordship, matter may kindly be possible for the time being.
I mean,
Yes, my senior. Just, wait a minute.
21.
Twenty-two may be taken up, my lord.
Sir, 21, 22, 32. ওই আমার কাছে কপিটা আচ্ছা ঠিক আছে হবে এখন আয়ের
Huh? Page কি ধরে নিবে? হ্যাঁ?
এর আগের দিন
তাই নাকি? RSL করতে দাও। The questions of the same. BC, এটাই তার মানে।
22 is what? Second appeal or?
Second appeal, both same, my lord, almost analogous.
Order.
Almost analogous.
Yes. Why it was re-registered as regular second appeal? On last occasion, earlier it was registered as second appeal
Yes,
against order.
okay, yes, my lord, it should have been, my lord, RSI, that is why, my lord, court directed.
Yes. What is your submission?
But in the both appeals, my lord, the same questions are involved. Substantial questions are same in both the appeals. Fact is also same.
Now it is registered as.
Second appeal.
regular
RS.
second appeal.
Yes.
Whether substantial question of law has been formulated.
Yes, yes, formulated.
Formulated.
Yes. That was done on 31st of March 2021.
Formulated when it was not a regular second appeal.
No, it was it was appealable order, but registered later.
Wrongly registered as SAO.
It was wrongly registered as SAO.
But in an SAO, the substantial question of law was formulated. Whether it,
I think, my lord, that subject to what my learned friend will say, I think, my lord, that will also cover here. Second, যেটা substantial question of law আগে frame করেছিল ওগুলি তো থাকবে।
by which date?
That is 31st March 2021.
Oh, that should be. Okay.
Only it was a technical fault of the registry, my lord. Instead of RSA, they registered it as SAO.
Three questions were.
Yes. The lawlessness is the third aspect of the case, my lord. Here what happened, my lord? The respondent filed a suit against some persons who are not in possession of that paper. The appellant was in possession of the property of his own right since 1980.
Since
1980.
80.
Now, what happened, my lord? He filed a suit against some persons who are not in possession and obtained a virtually consent decree. If you also see at page 14 of IA, my lord, in this case, 805.
Page. Which IA?
805 of the IA. In this case, 805. IA 805 of
This IA is for?
My lord?
This IA was for what?
IA 797.
No? Kunda. No, no,
797.
805.
Yes, 805.
Yes.
What for this IA was filed?
My lord, that was for interim order. In this
This
matter, my
is
lord.
disposed of.
Yes, yes, page 14 may be seen, my lord.
Page 14.
No difference. This is the suit filed by the plaintiff, my lord, Pankaj Sarda, against Basanti Singh and others. On the first day itself, my lord, the defendant appeared and defendant by, my lord, your lawful find. Defendant numbers, by petition number so and so admitted the case of the plaintiff.
এই আইটার একটা এক্সট্রা কপি আছে রাইট
একই তো, ওটার সাথে একই। ওটার সাথে একই।
এক্সট্রা কপি না পেজিনেশনটা মিলতেছে না
Annexure 1.
মিলে
এখানে 19 এটা 19 আপনারটা 14 না এটা এখানে 19
Velocity got it? The petition is supported by an affidavit. I heard both sides. Suit is defeated already.
This suit was for.
My lord, this is a fraudulent decree they have obtained. My lord, against some persons who are not in
This
possession
suit
of the
was
land.
for declaration of right title and interest and for recovery of.
Recovery
or-
possession.
Recovery or confirmation.
Yes. Recovery of possession.
Recovery of possession.
Recovery of possession. My lord, that
your lordship find, my lord. This is ejectment of the dependents. At page, my lord, next page, degree, 16 degree. At page 17, your lordship find, my lord. A decree for ejectment of dependents, anyone claiming for them under the class position, removal of pursuance, all obstacle, hindrance, arrow, at the end of the revision. This is for ejectment.
Yes.
So now, my lord, I file, my lord, an application under order 21, rule 97 and other. My lord, in this aspect, my lord, I want to, because the
No,
trial
in
court has,
which suit? In which suit against this
my lord,
Basanti Singh? In that suit you filed order 21 rule
in
46
the execution case.
in the execution case.
Case, my lord, because nowadays, my lord, after the amendment, because all things are to be decided in the execution case itself, my lord. That your lordship find. Order 97, rule 101.
Okay.
Order 97, rule 101.
Order 21 rule.
My lord,
Order 21.
order 21. Order 21, rule 101.
Okay, yes. All questions are to be decided. Thereafter. Yes.
All questions, including questions relating to right, title, or interest in the property arising to parties to a proceeding on an application under Rule 97 or Rule 99, or their representatives, and relevant to the execution of the application, shall be determined by the court dealing with the application and not by a separate suit. So nowadays, separate suit cannot be filed. And for this purpose, the court shall, notwithstanding anything the contrary contained in any other law for time in force, be deemed to have jurisdiction to decide. Now, that is why, my lord, we have to file a petition. So far, my lord, this scope of this, my lord, is concerned, my lord. I am just relying on a judgment of Supreme Court 2020 16.
No, before you come to judgment.
My lord,
some facts. What happened? You
facts I
filed-
am coming, my lord, because facts are to be decided, my lord, on the what I have to do, my lord, satisfy. 2020 16 SCC 230. My lord, all other earlier judgments have been deferred here, my lord. That is why I am not going to.
230.
My lord, the Planet Trial Court, which is appellate court, has gone wrong, my lord, in this matter. My lord. That is why, my lord. Paragraph 40. Here, my lord, they have quoted Rule 97, obstruction to the property, then rule order para 41, 99 has been quoted. Now, para 42.
Yes.
Para 42. This court held that the view taken by the High Court that only remedy available to a stranger to a decree who claims an independent right. My lord, this is that question. Whether I have an independent right, title or interest in the property to pursue a remedy under Order 29, Rule 99. Or answer. The court held that a stranger to a decree is entitled to agitate his or her grievance and claim for execution of an independent right, title, interest in the decretal property, even after being dispossessed in accordance with Order 21 Rule 99. Order 21 Rule 97 deals with the stage which is prior to actual delivery of poison and the grievance of the obstructionist can be adjudicated upon before the actual delivery of poison or liquid holder. In other words, both sets of remedies are available to a stranger of the decree. The High Court totally ignored a scheme of Order 21 Rule 97 in this connection by taking the view that only remedy of such agenda is with the decree lies under Order 21 Rule 99, and he has no capacity to get education of his claim prior to actual delivery. And I am skipping over this one also. I am not. Now, the lordship may come to para 43. Order 21 Rule 101. All questions.
Where are these?
Para 43.
Yes.
Relating to right title interest in the property arising between the parties who are proceeding on an application of the order under Rule 97 or 99, or the arithmetic shall be determined by the court and not by a separate suit. Speaking to the judgment, if we find that any person in the clause is deliberately widening the scope of the power, so if the executing court could adjudicate his claim made in such application under order 21 Rule 97. Thus, by the use of the words any person, it includes all persons registering the delivery of poison, claiming right in the property, even those not bound by the decree, including tenants and other persons claiming their own right, including extended. These principles have been reiterated, in which it is held under provisions of Order 21 Rule 99 will not defeat the right of a third person claiming to be in possession of the property. Third person claiming to be in possession of the property forming the subject matter of the decree in his own right. Well, this is the matter question. This question, second appeal question is also framed this. Well, in his own right, he must possess that land. This is the point, my lord, which we have to educate. The property forming the subject matter of the decree in its own right to get objection decided under Rule 97 at the stage prior. 45. In such a so, from the rule extracted, it is easily seen that language of the rule is peremptory and the powers given to the executive court under the said rule are plenary. The powers given to the executive court under Rule 101 are not qualified or hedged by any restriction. On the other hand, shows that executive court is required to execute upon all questions mentioned in the said rule, as if it had jurisdiction to deal with every question that may arise. By legal fiction, an executive court which may otherwise have no jurisdiction is invested with the jurisdiction to raise all questions under the said rule. In view of the settled position of law as it emerges from the decision, it is evident that the appellants were entitled, though they were strangers to the decree, to get the claim to remain in possession of the property independent of the decree. Well, this is important. Your losses may share for this. To get their claim to remain in possession of the property independent of the decree executed in course of the execution proceeding. The appellants in the fact set up such a claim. They sought a declaration of their entitlement to remain in possession in the character of lessees. Under Order 21 Rule 97, they were entitled to set up an independent claim even prior to their disposal. Under Order 21 Rule 101, all questions have to be executed upon by the court dealing with application and not by a separate suit. Upon determination of the questions referred to 101, Order 28, Rule 98, the court to issue necessary orders, the consequence of execution of a decree under Rule 103. Well, this is that point. Now, if you also see the questions framed by this court, hello. Whether appellate, well, first question, no. The law, substantial question of law framed by law. Whether the appellant could establish his possessory right in the premises since 1980, independent of the right of the decree holder, and thereby the decree holder is not entitled to execute the decree. This is the first issue. Substantial question of law. Whether Exhibit 7 on behalf of the Mahaprabhu deity gives significant right to the appellant, to the decree holder, and whether the decree holder can execute the decree against the appellant. Whether the learned court will add in law in not taking provision of Exhibit 4, which is tenancy agreement, although the same was not registered, the same can be considered for all the purpose, lead with other documents which were issued by the Silchar Municipal Court.
These are these substantial question of
My
law?
lord, my lord, here what happened, my lord, both the courts below went wrong in framing the issue. My lord, I'm coming to that first, my lord.
No, my query is whether these are these substantial question of law? Because these are questions of fact. How it qualifies to be substantial question of law?
Yes.
Or a second appeal to be adjudicated.
Yes,
First
my lord.
requirement is that substantial question of
This
law
is
has to be.
a question of law, my lord. If any document is not considered, that is also such, then I have to bring those judgments, my lord. And moreover, this question number 1B, which has been framed, my lord, that is important because the learned trial court as well as appellate court has framed the issue whether petitioner have non-habitual right over the property. Well, what plea I have taken, that is not the question, whether evictable or non-evictable, but whether I have an independent position that of the duty of law. That is the issue to be decided. That is why, my lord, I have placed the judgment of the Supreme Court, which from 97 onwards, all the judgments were considered. I have not placed all the judgments, that is right. The issue to be decided is not my independent right only. Not that whether I am evictable tenant or not, that is not that question.
What is your name? Shankar?
Shankar Das.
Shankar Das.
Yes.
And decree was against you.
Decree was not against me.
Against,
Decree was
against-
from persons who are not in possession of the land.
Okay, you file an application under order.
Order
21
21,
rule
rule
97. Then what the trial court held?
Trial court, my lord, that is why, my lord, I am coming to, if your lordship comes to the.
No, briefly tell me so that I know the facts.
My lord-
What trial court held in against your
both
that?
both the courts have held that he has not been able to prove that there is continuous possession and that there is they have become unevictable, non-evictable tenant by virtue of their possession and construction carried out on the suit land.
And his order 21 rule 97
has been
petition was
rejected.
Dismissed.
Dismissed by both the courts below. One aspect, my lord, subject to, my lord, what my learned friend will complete. One aspect, my lord, that I would like to highlight before your lordship. When the suit was filed, there are two suits. Item number 21 and 22. These are two suits, my lord. Dada bolbo. Fact bolbo. ঠিক আছে।
Why you should say?
My lord, he
Yes.
My lord, here, when the suits were filed, we applied for being a party to the suit. My petition was rejected. We even came to High Court. High Court said that you have the remedy. If decree is passed, then order 21.
So okay, during the pendency of the suit itself, you.
Well, we appeared and filed a petition to array as a party because we said that we are in possession of the suit.
Okay.
We are not there.
Now, your petition under order 21 rule 97 was decided against you,
Against me.
holding that you don't have continuous possession.
No, not continuous possession.
What?
I am not a non-evictable tenant. I could not prove that I am a non-evictable tenant.
You could not prove that.
Non-evictable tenant is not the purport of section order 21 rule 9799. Order 20, that is why I have placed the judgment, my lord. The trial court as well as appellate court gone wrong on this point, my lord.
Then the issue, substantial question of law has to be reformulated here. What we will decide in this appeal?
Yes.
Yes.
What is the substantial question of law which is involved?
My lord, that number 1, my lord, B, can be modified that not that whether I am an evictable or non-evictable tenant. We could establish possessory right in the premises, independent right of decree holder only, and not whether I am evictable or non-evictable. That is to be added, my lord. My independent right is to be only established, my lord. That it may be modified, my lord. And perversity is there, my lord, so far exhibit 4 and 7 is concerned. These are not considered. So perversity is a substantial question of law.
Okay.
So the first my lord, question may be slightly modified, my lord.
How? Suggest.
Whether appellate court appellant could establish its possessory right in the premises since 1980 independent right or decree holder and not the victim. Because that is not to be proved. As per order 21 rule 97, I need not prove, in that case, my lord, that thing will go. Whether I can prove it or not. That thing is not to be proved. Both the courts are wrong, my lord. By slightly modifying
No,
it first,
your submission is that requirement of proving possessory right is not necessary.
possessory right is only established. Not that I am non-effective enough. My possessory right independent of the right of the decree holder.
Where is the order of the appellate court, impugn order?
My lord.
Impugn order of the trial.
May I say, my lord, this matters may be taken up some other day. I have some problem in the tongue, my lord.
That can be done. Your lordship can keep this matter as part heard. Otherwise, my lord, of course, my lord, he has some difficulty, my lord. I will
No,
not
I'm
insist.
not keeping it part heard.
But
because
only, I will just indicate only.
Only issue is that whether substantial question of law is required to be reformulated. He's saying that requirement under order 21 rule 97 is that you need not to prove that you are non-evictable tenant. Continuous possession is enough.
On
Yes,
that
independent possession is enough.
On that query, my lord, I have a submission, my lord. If your lordship permits me, I can please. Now, the submission is this, my lord. Order 21, rule 97 and 98. His application was under order 21, rule 97 and 99. Sorry, 97 and 99. But the question that
99 comes after eviction.
exactly. So by his own conduct, my lord, own averments, my lord, it is established that he is in possession of the property. Now, if he is in possession of the suit land,
Then 99 is.
then 99 does not come. 97 also does not apply. Now, what could have been applied?
97 does not apply.
Yes, what could have been applied, my lord, is 101. Now, the application was not filed under 101. So therefore, the dismissal of the application, rejection of the application by the courts below, like cannot be said to be either illegal or perverse. Because they have gone into the merit of the case and the clear finding, if your lordship will kindly pick up the other matter, item number 21, my lord, in the item, because the brief, the paper, I mean the page initial.
Difficulty.
No, your lordship can adjourn it, my lord. I'm just trying to show your lordship the inconsistency, my lord. There is a clear finding of the trial court, as well as affirmed by the appellate court, that there is no document to show that the settlement took place in the year so-and-so, no evidence on record to show that so-and-so and so-and-so constructed the permanent structures within 5 years of tenancy. There is also no evidence to show that prior permission for construction, etc. was obtained from the concerned authorities by so-and-so and so-and-so. Also no evidence to show that so-and-so relinquished his right. His entire case is that his predecessor in interest had relinquished the right in his favor. And therefore, he continued to be in possession of the property and later he carried out the construction. These things are, on finding of fact, my lord, both the courts below have rejected this thing. Now, whether in the second appellate stage,
whether we can go into facts.
yes, these are the two crucial findings of fact. And the other thing is that, my lord, the point that the appellant is trying to urge is usually can be conceived of under 101, an application under 101. His application was under 97, read with 99, and where dispossession is a sine qua non. And your lordship will also
For 97 disposition is
no
not necessary.
for 99, and your lordship will also kindly take into account another fact that it is not a case that he is a stranger in a sense, because when the suit was filed seeking eviction, seeking right declaration of right title, interest and possession, he came to court seeking impleadment. Now the impleadment was rejected by the trial court. He came in on a revision before this honorable court. This honorable court had also rejected the revision petition, saying that if situation demands, then you can file a separate suit for protection of your rights. That order, your lordship, it is there in your
But
lordship.
he is stranger to this suit
Well,
because he is not made a party.
he is not
In-
made a party,
In that
but
sense, he is a stranger.
in that sense, my lord, he can be a stranger. But so to say that I did not know about the things, everything happened beyond my knowledge, my lord, that will not apply. And that these things, these observation of the Honorable High Court came in the year 2007. 2007, his suit, the revision petition was filed and it was thereafter dismissed. And for all long this period, my lord, he remained silent.
Who is in possession now?
He is in possession, my lord.
Okay.
They are obstructing.
They are obstructing
When
execution.
should we fix it? When should we fix it?
Third week of August.
Lordship, my lord, this is the only point. My lord, he has some difficulty, my lord. I will not object to this, my lord. Your lordship may kindly have it on a particular date, my lord, so that we can also come to it.
Suggest.
Yes, 30th of August, anything.
22nd,
22nd. Yes,
22nd.
22nd.
On request of learned counsel for both the sides. This matter is, registry is directed to list this matter again for hearing on 22nd of August 2020.
Well, it may be given some precedence, my lord. Your lordship has at least heard it for some time. Otherwise, my lord, looking at the length of the list, my lord, it will always reach.
No, if you make mention on that day, you may make mention
Yes.
for upgrading the matter on that day. Today, I'm not requesting because I'm even unaware about the roster.
Now, if your lordship is keeping it as part heard, my lord, in that case, it will automatically come before your lordship.
Part heard, I'm not keeping.
Much.
Lordship, I'm very sorry. In item number 23, I was present at the time, Your Lordship.
You say
Interest us.
Okay, show it. Item number 23. What is your name?
Yes, Roy, Your Lordship.
Yes, Roy. Yes, Roy. Presence to the public. I will show your presence.
Your Lordship.
I'll show your presence.
Yes, much of it, Your Lordship.
Yes. I'm sorry, Lordship, I. Lordship, herein I have also filed one IA Lordship for to bring on record the policy, insurance policy, that IA is 1752.
Well, there is an order by this honorable court saying that this application will be considered at the time of hearing of the appeal.
I do not have any issue with that, Lordship. I can do the hearing of the appeal, that's no issue. Because policy itself, I don't think they are also denying, we are not also not denying the policy. I've just gotten on record because the trial court relied on Balakrishna case and Balakrishna was sent back for the court to peruse the policy. Otherwise, the policy I have also annexed with my memo of appeal.
This IA has been disposed of or not?
No, no, Lordship, it is pending.
IA has not been disposed of, my lord. The honorable court said that it will be considered along with the appeal.
Now, what is to be taken up first, appeal or this is
Well, the sequence
41 rule 27 petition.
27. Well, sequence wise, my lord.
This petition has to be heard first
Yes. Sequence wise, my lord.
because it may be allowed, it may not be allowed.
Yes.
Thereafter, appeal has to be heard.
Yes. So if your lordship, subject to what my learned friend will argue, my lord, your lordship can first decide this appeal and decide this application and take up the appeal for. Otherwise, also, my lord, the question is that the appellant is urging here, that is not with regard to the coverage. It is only with regard to the extent of coverage. The policy is, they say that the policy covers only to a limited extent, the policy covers the risk, and therefore I will not be entitled to the amount of compensation which the tribunal has directed to be paid. They say that it will be a lesser amount of compensation because of the conditions in the policy. This is the reason, my lord, they want to bring it. But one question that I would submit before one submission I will advance before your lordship, my lord. These questions were never raised in the WS. This was not even also put forth during cross-examination, that the policy does not cover this extent, that it does not cover to that extent, not. And order 41, rule 27, your lordship knows, my lord, your lordship has dealt with it numerous times. There are 3 contingencies on which an application can be allowed. The 3 contingencies are all mentioned there. This application, my lord, if your lordship will have a look, my lord, neither of the contingencies are available in this case. Order 41, rule 27, if I can just read out to your lordship, my lord.
Since he is arguing, Lordship, I am sitting for the time being, though it is my petition.
No, let her submit.
No, let
Lordship,
her come in, my lord. I am not to injunct anything, my lord.
No issue, Lordship. It can go other.
Follow the law.
Oh,
The right-
If that is what, my lord.
The
If the
applicant should submit first.
Yes, yes. Well, I am not injuncting her. I am just indicating, well, what the honorable court on that day said. That it will be heard together with the appeal memo.
So it has to be disposed of first.
Yes. Let her place, my lord. I'll reply.
My simple argument in this case, Lordship, in this application is, Lordship, the policy is not denied by anyone. Based on the policy only, the compensation was settled on the insurance company, Lordship. Here, the main question is that the claimant in the claim petition, as well as in evidence, as well as the judgment, Lordship, it is mentioned that they were gratuitous passengers. So our contention is on gratuitous passengers only. Something which is not denied, Lordship. And if they are now denying the policy, Lordship, policy itself, then it is a different issue. Then, Lordship,
I assume that they are not denying the policy. They are saying that as it was not brought on record by you during inquiry before the tribunal. Therefore, order 41, rule 27 does not allow us.
then Lordship, how the court below has passed the judgment. I'll read the part of the judgment where the court has relied on the policy itself.
Yes, without policy, how?
How the court could pass, and court has relied on Balakrishnan case, Lordship, and that is the reason I brought in this. And in my petition also I have mentioned that it is not that my language is very clear here, Lordship.
Yeah.
Paragraph 8, Lordship, that neither the policy is in dispute in the present case nor the terms of policy, but still the appellant is desirous of exhibiting the policy so that this honorable court can be held in proper adjudication of the case. Because, Lordship, the trial court has relied on this policy and passed the judgment and relying on Balakrishnan case. Balakrishnan case, Lordship, the apex court had sent back the case to the trial court so that the policy can be looked into. I've got that Balakrishnan case also. So Lordship,
What it says?
Lordship, the relevant part is paragraph 22 and 23. Last page, Lordship, page 10, last page of the back. No, backside. 22 and 23. I'll read, Lordship. In view of aforesaid legal position, the question that emerges for consideration is whether in the case at hand, the policy is an act policy or comprehensive package policy. There has been no discussion either by the tribunal or the High Court in this regard. True, it is therefore us, an excerpt P1 has been filed, which is a policy issued by the insurer. It only mentions the policy to be comprehensive policy, but we are inclined to think that there has to be scanning of the terms of the entire policy to arrive at the conclusion whether it is really a package policy to cover the liability of an occupant in a car. 23. In view of aforesaid analysis, we think it appropriate to set aside the finding of the High Court and the tribunal as regards the liability of the insurer and remit the matter to the tribunal to scrutinize the policy in a proper perspective and if necessary by taking additional evidence as if the conclusion is arrived at that the policy in question is a comprehensive package policy. The liability would be fastened on the insurer. As far as other findings recorded by the tribunal and affirmed by the High Court are concerned, they remain undisturbed. Lordship, in light of this, Lordship, may I take Lordship to the judgment, Lordship? Judgment passed by the tribunal, Lordship. Page 17 of my memo of appeal, Lordship, and internal page 11 of the judgment, Lordship.
Yes. Yes.
Yes. Para 16, Lordship. The accident took place due to rash and negligent driving by the driver of the offending vehicle owned by the OP1 and insured with the OP number 2, National Insurance Company. From where did it come, Lordship? There is no dispute that the offending vehicle was covered by a policy of insurance, which was a package policy. From where did it come, Lordship? Admittedly, the vehicle was a private car. Regarding occupant in a private car, Honorable Supreme Court in National Insurance Company Limited versus Balakrishnan and other reported in 2012 to TNMAC 637 SC observed as follow.
Now, whether you exhibited a policy before,
No, we did not.
whether the claimant exhibited.
No, because it is admitted fact and the court, how the court could come to this conclusion, Lordship, when it was not exhibited, not done by anyone, and the court has fastened the liability on the insurance company. That is why we want we have filed this Lordship. Without the policy being present before the court has written these things and then fastened the liability without looking into the terms and condition of the policy. That is why we need this additional evidence, Lordship.
Now what you propose by order for?
Lordship, I propose that the policy may be brought on record. Though in the memo of appeal itself, I had annexed the policy, but it is since
Now,
the
in
trial.
Balakrishnan case,
Huh.
whether policy was before the tribunal?
No. It was only before the apex court P1 was given. That's why the court has sent back the.
From where you're saying that?
In the judgment, it's the Balakrishnan judgment itself, Lordship, paragraph 22. Fourth line, Lordship. True, it is before us, Annexure P1 has been filed, which is a policy issued by the insurer.
No, but there is no indication that it was not filed before.
No, then it is in the paragraph itself, it becomes clear, Lordship. We are inclined to, there was a scanning of the entire to arrive at conclusion. In view of the.
It only says that court did not apply mind to find out whether it is a. But the policy was not before the tribunal. Is there any indication?
Yes, this itself, Lordship, paragraph 22 and 23 I have read,
Where?
because it was presented as Annexure P1 before the apex court.
No, that is
So,
okay. But it, whether in Balakrishna's case also, the policy was not presented before the tribunal, as in this case.
I'll just go through the.
Because
fact.
there would be a question of cross-examination
Yes.
of exhibiting person who will be exhibiting the policy.
That right they will get, Lordship. That is true. Because they
ordered
will
by-
have all the rights to.
If order 41 rule 27
True.
petition is allowed,
Yes,
then they will have to be given right to cross-examination.
that is correct, Lordship. They will get that opportunity.
But
In fact,
there-
if they want
therefore,
to,
Balakrishna's case only says that, what I have understood, that as Annexure P1, the policy was placed before the Supreme Court. And it held that there was no application of mind on the policy by tribunal as well as by the High Court.
I'm just reading the whole judgment, Lordship, to find out that particular.
There is somewhere indication, then it may help.
Yes, Lordship, I'm trying to find out.
Otherwise, if there is no evidence, on what basis the tribunal said that it is a package policy?
That's if there is no evidence, that's why we came in appeal, Lordship. And moreover, the fact that they were gratuitous passenger from the very beginning, they have been saying they are the gratuitous passenger. Otherwise, also, I think, Lordship, this will need to be remanded back because we are challenging even the quantum, the salary. Different kind of salary certificates are exhibited in the case. And for the policy also, I think ultimately the case has to be remanded back. They will get an opportunity to cross-examine. And also, I think for their income thing, otherwise, it is, I have gone through the records, Lordship, it is detrimental to their own compensation amount.
No, the court, the
I'm trying-
tribunal said that there is no dispute that the offending vehicle was covered by a policy of insurance, which is
Yes,
package policy. On what basis it said?
no basis. And that is the reason, Lordship, I have brought that on record, this, I have filed this, because there was no basis for the tribunal to pass this observation of the tribunal. Paragraph 16 and 17. Because hence in this case, as the vehicle was insured against under a package policy, the risk of disease being an occupant is covered.
Here the claimant was,
Claimant is the mother, Lordship, or her daughter died.
in a, which vehicle?
In the vehicle she was traveling in, Lordship. The passenger in the vehicle, AS 11K091.
Is it your submission that the policy is not a comprehensive policy?
Lordship?
It is not a package policy?
No. Limit of liability. Two things.
It is a package policy.
It is a package policy, but two things. There, in the policy itself, it is mentioned that premium was paid for 5 persons traveling in the vehicle and the liability is 1 lakh for each. And second part is that since they were traveling in the vehicle and they have admittedly said that they were gratuitous passenger. In the claim petition, in their evidence as well as in the judgment, first page itself, it is written that they were gratuitous passenger. In that view of the matter, can the insurance company will saddle with liability of how much?
Which exceeds the
Huh.
amount mentioned in the policy.
But the court below did not have any opportunity to look into the policy because it was not exhibited, neither the claimant exhibited it, nor the insurance company. So for proper my humble submission is that for proper adjudication of the matter, the policy is, yeah, otherwise I have annexed it with my memo of appeal also. And they have not objected to that.
As memo of appeal as annexure,
Lordship,
as any.
annexure, yes, Lordship.
Okay, make your submissions. Anything else?
That is my humble submission, Lordship, that this petition may be allowed and 27, the parties to refuse to admit evidence, the parties seeking to be said, exercise, such evidence not within the law could not be produced, the appellant requires any law to produce a witness to witness to enable B. They are challenging 27A, but I am into 27B. The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or any other substantial cause. I'm on that logic. Because without the policy, how any court can pass a judgment? So my submission is that my petition may be allowed.
No, my lord, I believe the lower court records is with your lordships, my lord. LCR is with your lordship.
Yes, okay. LCR some. Yes.
Now, in the LCR, my lord, your lordship file will find in the claim petition, we have given a reference of the policy. If your lordship is holding the claim petition, my lord, the reference is at page 4. It starts from bottom of page 3 and the mention of the policy number is at page 4. Has your lordship found it, my lord?
Page 4, where?
Page 4 top, your lordship will kindly find the policy number. Policy number valid up to 6/9/2016 with effect from 7/9/2015. Now, this is the policy number that we gave in the claim petition. And we said that one of the vehicles being the vehicle insured under this policy, the claim has to be paid by them. That was the claim. Now, kindly see their written statement. The written statement filed by the National Insurance Company. Now, the written statement of the insurance company runs into 5 pages, 27 paragraphs in all.
Yes.
Not even a whisper anywhere that this policy does not cover the risk of the risk of the victim.
If my friend will look
It's
at
a-
paragraph
wait,
11.
wait.
Paragraph 11.
Not even a whisper that this policy does not cover the risk of the victim. The bold statement that is made, that comes at paragraph 15, page 3. The liability of the OP answering OP, if any, is restricted within the scope and terms of the policy of insurance. If any, that is also qualified by if any, and the provision of the Motor Vehicles Act and terms of the policy of insurance, if any, and the provision of the Motor Vehicles Act and rules framed thereunder with the amendments made from time to time. This is a denial as evasive as anything. There is no specific averment saying that the policy number which I have quoted in the claim petition does not exist or does not cover the kind of risk which the claim petition is trying to espouse. And the anxiety of the appellant's counsel is also to be taken into account. If your lordship will kindly read the paragraph 11. That the answering opposite party does not admit any liability to satisfy any award in this claim and begs to submit that the claim cannot be admitted by answering OP, as because the owner of the alleged insurance vehicle number so-and-so has not given any insurance information to the OP. Does it anyway say that the policy coverage is not there? Nor furnish the concerned policy document to the answering OP. Hence, the present case against the OP is liable to be dismissed. Where is the plea that there is a policy, this policy does not cover this thing, and the limit of coverage is this? Now, there was a lacuna in your case and you try to fill up that by bringing on record an application for adducing additional evidence. Is it permissible? If it has to be permissible, then it has to be permissible on the 3 preconditions. And the 3 preconditions have been read out to your lordship. I will not pardon your lordship, but only say that since their emphasis is on clause B, appellate court requires any document to be produced or any witness to be. Why your lordship would require any witness to be adduced? It is your burden to say that the tribunal, that they show that the order of the tribunal is wrong or the award of the tribunal is illegal. It is not court's burden to see whether any witness is necessary or not. These 3 conditions. And what is the application, my lord? If your lordship will kindly take up the application for a moment. Kindly see the averments made in the application. Does it anyway refers to either of the conditions made in order 41 rule 27? An application running into 13 paragraphs. The 13th paragraph ends with application made bona fide. Now kindly see what are the contentions. First paragraph, applicant is the appellant has filed the appeal. Very well. Second, applicant preferred this application on behalf of so-and-so. Fair enough. Third paragraph, it is pertinent to mention here that the policy was not in dispute in the case. As per the insurance policy, so-and-so was paid for so-and-so coverage, rupees 1 lakh for each passenger. In that view of the matter, the appellant is only liable to pay so-and-so as per compensation as per policy so-and-so. In the present case, then the policy is enclosed. Thus, having no other option, the applicant company filed one appeal before the High Court. Neither the policy is in dispute in the present case, nor the terms of the policy, but still the applicant is desirous of exhibiting the policy so that this honorable court can be helped in who is seeking your help. It is your appeal, it is your burden to show that the order of the award of the tribunal is wrong or illegal. Can by any stretch of imagination, my lord, it can be said that either of the preconditions in order 41 rule 27 is met. The first condition, visibly, my lord, that does not appear. The court from whose decree the appeal is preferred has refused to admit. You have not offered any evidence. So clause A does not come. clause A, as a party seeking to produce additional evidence establishes that notwithstanding.
She's pressing clause B only. That
Now, clause B, my lord, the clause B cannot be praised by her. Clause B consists of a situation where your lordship feels that amount of evidence is necessary. That is a power given to the honorable court. That is not a remedy given to the appellant or the respondent for that matter. This is a condition given to the appellate court, that if the appellate court finds it, this is to be exercised. This is on the basis of the discretion that the appellate court enjoys in deciding an appeal. I'll place one judgment before your lordship, my lord.
after filing of their application, suppose suo motu appellate court has not called for. this
Yes,
policy.
then clause B will come into application. If your lordship suo motu permits, my lord.
I'm saying that assuming that suo motu,
Yes,
nothing has been done.
no,
But on their application, court feels that perusal of this document would be necessary in passing the
No.
appellate courts.
no, then the question will come that this is not on the basis of any application. This is on the basis of your lordship suo motu call.
No,
If your lordship, my lord, that is my submission, my lord. I'm just making my submission like this, my lord.
it only speaks that if court requires the document to be produced.
Requires any document to be produced or any witness to be examined to enable it to pronounce judgment.
Or for any substantial.
Now, this substantial cause, my lord, that's why I said, my lord, the 2012 judgment. Union of India versus Ibrahimuddin, 2012 judgment, my lord. This substantial cause has to be understood in the context of the discretion that the appellate court will exercise. It is not any cause as such. And it cannot be utilized. My lord, the Honorable Supreme Court has said that this cannot be utilized to fill up any lacuna. My lord, I'll just read out the word. I'm getting the judgment to be placed before your lordship, my lord. The words of the Honorable Supreme Court is like this. The inadvertent, my lord, may I just read it very slowly? The inadvertence of the party or his inability to understand the legal issues involved, or the wrong advice of a pleader, or the negligence of a pleader, or that a party did not realize the importance of a document, does not constitute a substantial cause.
One more query. This is an appeal under MV Act, where the strict principles of CPC is not applicable.
Yes.
So whether the provision of order 41, Rule 27 in a proceeding under MV Act, even at appellate stage, is applicable in its full rigors.
No, my lord, there are judgments. I must be fair to the Honorable Court, my lord. There are judgments of this Honorable Court also, where this Honorable Court has taken recourse to this provision to permit adducing of additional evidence. There are judgments. I'll not deny that. But the question is whether to invoke this power.
No, there are two. We may permit adducing of additional evidence. We may also permit production of a document.
Yes.
Without permitting additional. So that in the instant case, suppose we don't allow this application, still there is no bar on perusing the policy which is annexed along with the memo of appeal.
Yes. Yes. Therefore, my lord, I am just, in my next submission, my lord, I am just coming to the root of the matter. Why and for what reason this application is filed? If your lordship will kindly see the ground in the memo of appeal, my lord, the memo of appeal, the principal ground raised is that the policy in question covers the risk of an inmate of a vehicle, the occupant of a vehicle, to a limited extent. And that particular sentence is repeated in paragraph 3 of this application. That the extent of cover is only rupees 1 lakh. That is the ground that they urge principally in the appeal. And why they want to bring this? The reason is that there was no evidence laid before the tribunal. You are trying to interdict the judgment of the award of the tribunal on some ground on which you never raised any plea. Is it permissible in law? My lord, when the written statement was filed, there was no specific denial that the policy does not cover unlimited liability or that the policy covers a limited liability. No denial of that point. And now you want to say that the judgment of the tribunal is wrong because of this, because our policy says this and therefore will not cover. My respectful submission, my lord, this Order 41 Rule 27 application should not be allowed, it should be rejected. And even after rejection of this application, if your lordship would like to peruse the policy, that will bring us directly to the point. Directly to the point of appeal. And on that point of appeal, my lord, this is conclusively decided by Honorable Supreme Court, followed by a decision of this Honorable Court, where I argued the same ground. And this Honorable Court has rejected it. I'll just show that judgment to your lordship.
No, but I could not get your second point.
My lord, the ground which the appellant is now agitating
In appeal.
in the appeal, the principal ground. Why they want to bring this policy? Because in the appeal, the principal ground is that there is a limited liability, limited coverage for the occupant of the occupant of the car, and that coverage is up to an amount of rupees 1 lakh. And therefore, we are not liable to indemnify the entirety of the award. That is the principal ground, as I have understood.
Gratuitous passenger is the principal ground. A.
Gratuitous passenger, that is why he is an inmate. Otherwise, he would not have been a gratuitous passenger. This is redundant. Now, that is the principal ground urged. That because she was an occupant of the vehicle and the occupant, for an occupant, the limit of liability is rupees 1 lakh. So, we are not liable to indemnify the entire thing. Now, this exactly the same ground was urged and argued by me in an appeal. This Honorable Court, my lord. And the judgment.
No, we'll hear the appeal. She has not made.
Then also I get the first chance, I suppose.
Yes.
Then
Okay,
So,
okay.
no,
I
I'll come to the
No,
appeal.
we'll
I'm just
hear it today, now itself. I am disposing of the petition under order
41 Rule 27.
41 Rule 27.
Now, therefore, my lord, even if that ground is to be urged in the appeal, which in my respectful submission is an exercise in futility, therefore, this application does not even deserve any consideration. Because even if your lordship will allow this application, my lord, it will be a sort of redundant exercise, because on the basis of the ground on which, for which, my lord, this application is preferred, my lord, that ground does not stand legally, because there is a pronouncement by this Honorable Court, followed by a decision
No,
by a Supreme Court.
Otherwise also, your policy is on annexed along with the
memo of appeal.
memo of appeal. I can peruse that memo of appeal.
Yes, Lordship.
As in Balakrishna's case also, it was annexed as P1.
P1. And this is Lordship, appellate court requires any document to be produced, an or. So that since it is there is, and moreover, my learned friend
okay,
himself is submitting that even if the petition is rejected, then also I have even if it is
Now-
not rejected, so what is the wrong in allowing the petition?
No,
I'm
there is
also in
a wrong, my lord. The wrong is because it will set a wrong precedent. Your lordship's judgments are used as precedent. That is why, and therefore, my lord, I am emphatically saying, my lord, I will be relying on this judgment of the Honorable Supreme Court, Union of India versus Ibrahimuddin. I'm just 2-3 minutes, my lord, I am giving the citation.
Yes.
No,
Because
even
that
I
Honorable
have
Supreme Court
judgments
has
on
very-
that point, Lordship, that additional evidence can be deduced. So-
No, can be adduced is one thing. Can be adduced is one thing. No one is denying, because can be adduced is conceptualized from the provision of Order 41
And
Rule
where is the
27
question
itself.
of filling up lacuna, Lordship? If the trial court itself mentions in the judgment about the policy. Where are we filling up the lacuna? Ibrahim judgment is that filling up lacuna, that cannot be allowed.
No.
We are not filling up any
Please
lacuna.
don't make a submission without reading the judgment.
Lordship, it is difficult to argue this way. It's very difficult. to
No, Lord,
argue. If
my lord, there can be a limit to
I'm sitting down,
making
Lordship,
submissions
like
to
a
me.
submission.
I am making a judgment which he has not even read
make-
out.
Make your submission in main appeal.
Yes, my lord. No, I'll make my submission in the main appeal after she finishes, my lord.
Yes.
Otherwise, my lord, that will not be, that will
Yes.
never, otherwise also, my lord, she is the appellant, so she should argue first. But the only thing is that, my lord, this judgment I have cited, because this has a nexus with the ground that the appellant is trying to urge in the application for, application under order 41 rule 27. And the purport of this judgment is Ibrahimuddin judgment is that the application for order 41 rule 27 has to be heard
How
along
much
with the
time will
appeal
you
memo.
Take in main appeal.
Lordship?
Main appeal, we can finish it today itself, no?
Yes, we can do Lordship if time permits.
Yes, because we have 45 minutes.
Yes.
Yes,
Only one point is involved.
yes.
No, not only one point.
Allah, I
As
said
well
that is the
as,
principal point.
uh,
There are many other grounds.
Okay, if I am disposing of this appeal, I am rejecting the order 41 rule 27 application. I'll give reasons later on in chamber. I'll write the judgment. You may make submission in the mail.
Yes. I have just, with the citations, I have written a short note, Lordship. And that way I'll take on. Lordship, first of all, let me come to the quantum first. Oh, first of all.
Yes.
I'll read the judgment, Lordship. It is page 7 of my memo of appeal, Lordship.
Yes.
By this judgment, I intend to dispose of the petition filed by claimants, mother and younger brother of the deceased under section 166 of the Motor Vehicle Act 1988 as amended up to date, praying for award of compensation of a sum of rupees 1,07,86,756 for the death of one late Sabita Das, herein after referred to as the deceased, in a road traffic motor vehicle accident that had occurred on 29/7/16 at about 2:50 p.m. at Kalinagar Part 8 under the jurisdiction of Panchagram PS in the district of Hailakandi. Case of the claimants in brief is that on 29/7/2016, the deceased was proceeding towards her residence from Silchar as a gratuitous, Lordship, this I'm giving emphasis on these words. Gratuitous passenger, it should be, I think, in N is written, in the Maruti Alto 800 LXI bearing registration number AS11K 0913, that the vehicle was driven by its driver in a rash and negligent manner, for which when it reached Kalinagar Part 8 at about 2:50 p.m., it lost control and dashed against the backside of another stationary truck bearing registration number so-and-so. As a result, the deceased sustained grievous injuries on her person and was immediately taken to Kalinagar PHC for medical examination and treatment, but the doctor declared her dead. In connection with the accidental death of the deceased, post-mortem examination on the dead body was conducted at the SK Roy Civil Hospital, and after completion of the post-mortem examination, the dead body was taken to the house of the claimants and cremated as per religious rites. It is alleged that the accident took place due to rash and negligent driving by the driver of the offending vehicle. It is also averred that in respect of the road traffic motor vehicle accident, Panchagram PS registered a criminal case, White Panchagram PS case number so-and-so under section so-and-so and investigated into the same. It is further averred that the deceased was 50 years old at the time of death and used to earn a salary of rupees 41,749 per month. This also I would like to emphasize because on quantum I'm challenging these per month. Being assistant teacher of Siddheswar Higher Secondary School, it is also averred that the deceased was the sole earning member of the family and the claimants were solely dependent upon the income of the deceased. It is furthermore case of the claimants that due to her untimely death, they are suffering from acute financial hardship. Hence, the claimants have come up with a claim petition before this tribunal seeking compensation of sum of rupees 1,07,86,756. In pursuance of the claim petition, notice was served upon the OPs. On receipt of notice, the OP number 2, National Insurance Company Limited, appeared and filed its written objection, denying the mode and manner of the accident as alleged in the claim petition. The insurance company also took defense under section so-and-so of the Motor Vehicle Act. The insurance company further pleaded that the amount of compensation claimed is excessive, inflated, and without any basis, and the claimant is not entitled to any such compensation. However, the OP number 1 owner did not contest the case. From the pleadings of the parties, following issues were framed. Whether Sabita Das, the deceased, died as a result of motor vehicle accident occurred on 29/7/16 at about 2:50 p.m. at Kalinagar, Part 8 under the jurisdiction of Panchagram PS. Whether the accident occurred due to rash and negligent driving of the driver of the offending Alto car bearing registration number so-and-so. Whether the claimants are entitled to any compensation. If so, what is the just reliefs the claimants are entitled? 4. By whom amongst the OPs the same is payable? Discussion, decision, and reason thereof. In order to prove the issues, claimant number 2, Srimati Sulekha Das, being mother of the deceased, tendered her evidence by way of affidavit as PW1 and marked several documents from Exhibit 1 to Exhibit 27 and Annexure 1. It may be noted that during pendency of the claim petition, the claimant number 1 expired and his name was struck off from the claim petition. Brother of the deceased, that is claimant number 3, also adduced evidence as PW2 and marked documents as Exhibit 28 and Exhibit 29. Claimant side also examined Senior Assistant Jyotish Chandra Dev of Office of the Inspector of Schools CDC Silchar as PW3, who also marked documents from Exhibit 30 to Exhibit 32. Evidence of PWs being subjected to cross-examination, the OP number 2 answering insurance company took full scope to cross-examine all the witnesses. Upon the closure of evidence of the claimant side, the answering insurance company did not adduce any defense evidence. Upon closure of evidence stage of both sides, I have heard argument advanced by the learned counsel for both sides. I have also perused the evidence on record in its entirety. For the sake of brevity and convenience of discussion and decision, the issues are taken up together without following the serial number of the issues. The finding on the specific issues are as under. It is the case of the claimants that the deceased died in a road traffic motor vehicle accident arising out of rash and negligent driving of a motor vehicle owned by the OP number 1, driven by a driver who also died in the same accident and insured with the OP number 2. The claimants preferred the claim petition under the provision of MB Act, and allegation of rash and negligent driving attributed to the driver goes to show that the claim application has been filed under Section 166 MB Act. Hence, it is incumbent upon the claimants to prove that the deceased died in a road traffic motor vehicle accident caused due to rash and negligent driving by the driver of the offending vehicle. To determine the negligence of the driver of the offending vehicle, it has been held in National Insurance Company Limited versus Pushpa Rana and another reported in 2009 Accident Claim Journal as follows. The last contention of the appellant insurance company is that the respondent claimant should have proved negligence on the part of the driver, and in this regard, the council has placed reliance on the judgment of Honorable Apex Court in Oriental Insurance Company Limited versus Meena Varial Supra. On perusal of the award of the tribunal, it becomes clear that the wife of the deceased had produced certified copies of the criminal record of criminal case in FIR number 955 of 2004 pertaining to involvement of offending vehicle. 2. Criminal record showing completion of investigation of police and issue of charge sheet under Section 279-304A Indian Penal Code against the driver. 3. Certified copy of FIR wherein criminal case against the driver was lost. 4. Recovery memo and mechanical inspection report of offending vehicle and vehicle of deceased. These documents are sufficient proof to reach the conclusion that the driver was negligent. Proceeding under the Motor Vehicle Act are not akin to proceeding in a civil suit, and hence strict rule of evidence are not required to be followed in this regard. Hence, this contention of the counsel of the appellant also falls face down. There is ample evidence on record to prove negligence on the part of the driver. It is an established principle of law that in a claim petition of proof to establish rash and negligent driving by the driver of the offending vehicle is not at par with the criminal case, where such rash and negligence is required to be proved beyond all shadow of reasonable doubt. In Kushmamma Begum and others versus New India Assurance Company Limited, reported in 2001 to SCC 9, it was inter alia held that the Honorable Supreme Court had the issue of wrongful act or omission on the part of the driver of the motor vehicle involved in the accident has been left to a secondary importance, and mere use or involvement of motor vehicle in causing bodily injury or death to a human being or damage to property would make the petition maintainable under Section 166 and 140 of the Motor Vehicle Act. In the present petition, the case of the claimant is that on 29/7/2016, the deceased was proceeding towards her residence from Silchar as a gratuitous passenger. Again, it is mentioned in the Maruti Alto 800 LXI bearing registration number so-and-so, that the vehicle was driven in a rash and negligent manner, for which when it reached Kalinagar Part 8 at about 2:50 p.m., the driver lost control and dashed against the backside of another stationary truck bearing registration number so-and-so. As a result, the deceased sustained grievous injuries on her person and was immediately taken to the local Kalinagar PHC for medical examination and treatment, but the doctor declared her dead. In connection with the accidental death of the deceased, postmortem examination on the dead body was conducted in the SK Roy Civil Hospital, and after completion of postmortem examination, the dead body was taken to the house of claimants and cremated as per religious rites. To prove death of the deceased arising out of rash and negligent driving by the driver of the offending vehicle, the PW1 produced certified copies of the criminal case registered against the driver of the offending vehicle bearing registration number so-and-so. On perusal of accident information report in Form 54, FIR and police report under Section 73 CRPC marked as Exhibit 1 to Exhibit 3, claim of the claimants is found corroborated, which fortifies the fact that on the aforesaid date, time, and place of occurrence, the accident occurred, and in respect of accident, a regular PS case number so-and-so under Section so-and-so was registered at the Panchagram police station, in which the investigating police officer, after completion of investigation, submitted final report under Section 73 CRPC, holding that the case was found truly established against the accused driver, Pratyush Chakraborty, who died in the accident of the Alto car bearing registration number so-and-so under Section so-and-so. The Caesar list marked as Exhibit 4 to Exhibit 8 speak that in connection with the accident, both the vehicles, that is the Alto vehicle and the involved stationary truck, were seized. The MPI report of the Alto car, while Exhibit 9 speaks that the front side of the Alto car was damaged. Hence, the case of the claimant that the Alto car dashed the stationary truck from behind stands established. The postmortem report marked as Exhibit 12 transpires the fact that postmortem examination on the dead body of the deceased was conducted on 29/7/16 at about 5:30 p.m. and the forensic surgeon opined that death was caused due to hemorrhagic and neurogenic shock following grievous head injury sustained. Therefore, the postmortem report lends corroboration to the claim of the claimants that the deceased died as a result of the Motor Vehicle Act accident occurred on 29/7/16 at about 2:50 p.m. under the jurisdiction of Panchagram PS. The answering insurance company, though cross-examined the PW1, but it failed to controvert the evidence of PW1 coupled with the documentary proof to negate the fact of accident arising out of rash and negligent driving by the driver of the Alto vehicle resulting in death of the deceased. Since claimant side discharged its burden of proof with the help of police papers that the accident occurred due to rash and negligent driving by the driver of the Alto vehicle, it is the duty of the insurance company or the owner of the vehicle to establish that accident did not occur due to rash and negligent driving of the offending vehicle, but the answering insurance company did not discharge its burden and the owner did not participate in the hearing. Police investigated the case, and in spite of the fact that a prima facie case was found as well established against him under the aforesaid section of law, submitted final report under section 173 CRPC as because the accused driver also died in the accident. So relying upon the testimonies of PW1 as well as relying upon the exhibited documents, the issue number 1 and 2 are decided in favor of the claimants, holding that the deceased died as a result of motor vehicle accident occurred on 29/7/16 under the jurisdiction of Panchagram Police Station due to rash and negligent driving of the driver of the offending Alto car bearing registration number so and so. In view of affirmative decision of the issue number 1 and 2, the claimants are found entitled to compensation. However, question remains regarding quantum of compensation that has to be awarded. Since this is a case of death, the age, income, and occupation of the deceased and number of dependents needs to be considered. Lordship, can I just have a sip of water? Lordship?
Yes, yes.
Thank you. Since this is a case of death, the age, income, occupation of the deceased and number of dependents needs to be considered. According to the claimants, the deceased lady Sabita Das was aged about 50 years at the time of her death. In the evidence on record, I have found service book of the deceased marked as Exhibit 31. Lordship, I'll also mark this Exhibit 31, Lordship, because my argument, I'm going to argue about this Exhibit 31. Since deceased was a government servant, I find the service book more reliable to determine age of the deceased. As per service book, date of birth of the deceased was 3/1/1966. Deceased died on 29/7/2016, and in that count, deceased was 50 years 6 months old at the time of her death. Hence, in view of the ratio laid down in Sarla Verma and others, Delhi Transport and others, Corporation and others, the proper multiplier to the age group of person belonging 46 to 50 years is 30. Learned Counsel for the Insurance argued that since the deceased was 50 years 6 months old, the multiplier 11 of the group group of 51 to 55 should be selected. But the Learned Counsel for claimant relied on Shashikala and others versus Ganga Lakshmanam and another 2015 9 SCC 150, wherein applicability of multiplier of 14 while computing amount of compensation for the deceased in a motor vehicle accident who was 45 years 5 months and 28 days was held justified. Observation of the Honorable Apex Court is in above referred case are reproduced as follows. Insofar as appropriate multiplier, the date of birth of the deceased as per driving license was 16/6/1961. On the date of accident, that is 14/12/2006, the deceased was aged 45 years, 5 months and 28 days, and the tribunal has taken the age as 46 years. Since the deceased has completed only 45 years, the High Court has rightly taken the age of the deceased as 45 years and adopted multiplier 14, which is the appropriate multiplier, and the same is maintained. Total loss of dependency is calculated at 16,82,310. 120,166 into 14. In the instant case, since deceased did not complete the age of 51 years, selection of multiplier 11 does not arise. Otherwise, the intention of the Supreme Court in formulation of multiplier table with indication of exact age group will be interfered. Hence, this court has selected the multiplier 13. Claimant Srimati Sulekha Das is the mother of the deceased, and claimant Sri Rabi Sankar Das is the brother of the deceased, who has already attained majority and has his own wife and children. Ravi Sankar Das deposed on as PW2 that the deceased was married to one Pijus Kanti Das on 30/1/1997, and within 1 month of her marriage, she left her husband's house and started staying with the claimants, and their marriage was dissolved by a decree of divorce dated 20/11/1998. In this case, it is admitted that deceased was a divorcee and was staying with the claimants after separation from her husband. In view of next kin certificate issued by Deputy Commissioner Kachar marked as Exhibit 29, claimants are the next of kin of deceased. PW2 also during cross-examination deposed that his mother Sulekha Das is entitled to pension of his deceased sister. That till date they have received an amount of rupees 5 lakhs to 6 lakhs as service benefit of the deceased, and the pension is under process. The PW2, however, deposed during cross-examination disclosed that he uses to maintain his own family consisting of his wife and a daughter. Since Ravi Shankar Das PW2 is a married person and he uses to maintain his own family, this court sees no reason to consider him as dependent upon the income of his deceased elder sister. However, the argument advanced by the learned counsel for the insurance company that mother of the deceased is also not dependent upon income of the deceased holds no water, as because she is entitled to pension of the deceased as per the deposition of PW2 during cross-examination. Moreover, dependency of PW1 remained unchallenged during her cross-examination. Moreover, deceased was a divorcee and had no children. Therefore, mother of the deceased is considered as dependent upon the income of the deceased. Hence, it is concluded that there is one dependent of the deceased. Learned counsel for the insurance company argued that deduction should be 50% as because the deceased being a divorcee, her status is like a bachelor maiden. As per Sarla Verma case, Supra, even if the deceased is survived by parents and siblings, only the mother would be considered to be dependent and 50% would be treated as the personal living expenses of the bachelor and 50% as the contribution to the family. In this case, the deceased was divorced and therefore, as argued by learned counsel for the insurance company, status of the deceased is like a bachelor. No claimant would admit that the deceased was a spendthrift, even if she was one. It is also very difficult for the insurance company in a claim petition to produce evidence to show that the deceased was spending a considerable part of the income on herself, or that she was contributed only a small part of the income to her family. Therefore, this court finds it reasonable and safe to stick to deduction of 50% towards personal expenses of the deceased as observed by our Honorable Supreme Court in Sarla Verma case Supra. As per deposition of PW3, an official from the Office of the Inspector of Schools as per service book and last pay certificate marked as Exhibit 31 and 32. Please, Lordship, I would like Lordship to mark this because I am arguing on them. Respectively, the deceased was an assistant teacher in Siddheswar HS School and her last gross pay was rupees 51,364. And after deduction of professional tax and GIS, her net salary was 50,956. It is seen that an amount of rupees 208 was deducted towards professional tax and rupees 200 towards GIS. Following decision of our apex court in National Insurance Company Limited versus Indira Srivastava and others 2008-2 SCC 763, Sunil Sharma and Bachender Singh 2011 ACC 552 SC, Vishakha versus Shripal Manu Day 1684 2012, Shambhati Sharma and Karan Singh 2010 SCJ 1968 SC. I am of the opinion that deduction towards other heads are not liable to be deducted from gross monthly salary to assess compensation except the professional tax and income tax. After deduction of professional tax of rupees 200 from gross monthly salary of rupees 51,362, monthly salary of deceased stands at rupees 51,364 minus 2 so and so 51,156. No income tax related document found exhibited in record except for the previous year. The document available on record do not reveal the deduction of income tax, recording the monthly income of rupees 51,563. Therefore, this court deducts the income tax as below. So that deduction is made. Hence, total income tax payable is rupees 36,386 plus 1091 is equal to 37,478. After deduction of income tax, I found the annual income is rupees 6,13,872 minus rupees 37,478 is equal to 5,76,395. After deduction of 50% towards personal expenses, loss of dependency is found to be rupees 5,76,394 minus rupees 288,197 is equal to 288,196. As per the recent decision of our apex court in National Insurance Company Limited versus Pranay City reported in 2017 SCJ 2700 reiterated in Lovely Devi Chauhan versus Freeram General Insurance Company Limited, Manu so and so, we are to add 15% of the annual loss of dependency, that is rupees 45,230 as future prospects, since deceased fell into the age group of 50 to 60 years and was in a permanent government job. To find out the total loss of dependency, we are to multiply the sum of rupees 2,88,197 plus 43,230 is equal to 3,31,427 by the multiplier 13. So the total loss of dependency stands at rupees 3,31,427 into 13 is equal to 43,08,551. As per the decision of the Honorable Apex Court in National Insurance versus Company Limited versus Pranay Sethi Supra, we are to add 15,000 under the head of loss of estate and another sum of rupees 15,000 under the head of funeral expenses to find out the just compensation. So the just compensation stands at rupees 43 lakhs, 8,555 plus 15,000 plus 15,000 is equal to 43,38551. Only which is just and reasonable compensation which the claimant number 2 is entitled to get. Accordingly, the issue number 3 is decided. The accident took place due to rash and negligent driving by the driver of the offending vehicle owned by OP number 1 and insured with the OP number 2 National Insurance Company Limited. There is no dispute that the offending vehicle was covered by a policy of insurance, which was a package policy that already I read that time, Lordship. Which was from where the court finds that it was a package policy. Admittedly, the vehicle was a private car.
No, otherwise you are admitting that it is a package policy.
Yes, I'm admitting, but from where did the court itself found? They have shown that they have mentioned it in their claim petition. Is it mentioned that it is a package policy or it is a mention? No, they have not. It is only the policy number is given. There is no policy. How isn't it perverse, Lordship? This finding itself, that without the policy being present, only the number was given. How the court came to the conclusion that it is a package policy? It is a different issue that I'm saying that I have submitted the policy that it is a package policy. But how did in the tribunal it was not there? Before Lordship, the policy is there. So how the tribunal could find that it was a package policy? Admittedly, the vehicle was a private car. This also, Lordship, from where did the court? Regarding occupant in a private car, Honorable Supreme Court in National Insurance Company Limited versus Balakrishnan and others reported in 2012 to TNMAC now observed as below. I've already read, Lordship, this part. Should I skip or should I read again?
Skip.
Yes, Lordship. Then, Lordship, I'm coming to paragraph 17. Hence, in this case, as the vehicle was insured under again the court is writing, under a package policy, the risk of the deceased being an occupant is covered. From where did the court find this? Therefore, the insurance company is liable to pay compensation in this case. This is the reason given. From where does that reason generate, Lordship? Hence, issue number 4 is decided accordingly, holding that the full amount of compensation is to be paid by OP number 2 insurance company. Learned counsel for the insurance company contended that interest shall not be paid at the rate of 6% per annum, and he relied upon the decision of our Honorable Apex Court in the case of Dharambai and others versus UP State Road Transport Corporation reported in Manu so and so. On the other hand, the learned advocate for the claimant submitted that the interest rate shall be paid at the rate of 9% per annum with effect from the date of filing of the claim petition, and he relied on the decision of our own High Court in the case of Sabir Sheikh alias Sabir Sheikh versus New India Assurance Company reported in 2019 to TAC 849 Guwahati. I have gone through the cited judgment there herein above referred to by the rival parties and found that the judgment of Honorable Apex Court is more relevant in the present context, as the Honorable Apex Court exclusively dealt with the provision of Section 171 MB Act, which deals with the aspect of rate of interest to be awarded in claim case. So, relying upon the decision of the Honorable Apex Court, I am of the judicial view that the prevailing interest rate of 7% per annum will meet the ends of justice. Therefore, in view of decisions averred at the issues, the claimant is entitled to compensation of rupees 43,38,551. And the OP number 2 National Insurance Company Limited is directed to deposit the amount of compensation within 30 days from today, along with interest 7% per annum with effect from the date of filing of the claim petition, that is 6/4/2017 till realization in full. Finished copy. So this is the judgment, Lordship. I have given a small written argument, Lordship. First of all, Lordship, I'm going into the quantum. Lordship, if Lordship will peruse the lower court record, Lordship. The low-court record, exhibit 16, Lordship, that is at page 58 of LCR, Lordship. Page 58, Lordship. This is a salary certificate, Lordship. In that, Lordship, the salary is mentioned as 41,749. And the date on that certificate is, Lordship, 26/8/2016. Then, Lordship, the next page itself, Exhibit 17, Lordship, page 59. This is also a salary certificate. And here the salary is mentioned, Lordship, 52,364 dated 21/2/2018. Accident had taken place on 29/7/2016, Lordship. Accident on 29/7/2016.
Yes.
So, Lordship, this Exhibit 16, which is just after the accident, it mentions a different amount. And the Exhibit 17/59, which is of 2018, which was issued in 2018, the salary has increased here, Lordship. Then again, I'm showing the discrepancy in the salary itself, because the quantum is calculated as per 52,364, Lordship, in the judgment. Then, Lordship, I'll request Lordship to peruse the evidence of PW1, Exhibit 19. Total in evidence of PW1, total salary for assessment year 2014-15 was rupees 4,12,512. So the monthly salary, Lordship, here comes to 34,376. And then again, these I have already written in my argument, Lordship. These are all page number and everything is mentioned in my short note. Then, Lordship, as per evidence of PW1 itself, as page 25 of LCR, Lordship, in Exhibit 20, total salary for assessment year 2015-16 was rupees 4,48,168. Thus, the monthly salary comes to rupees 37,347. Moreover, the gross salary is not mentioned in this exhibit, Lordship. It is the tax return, Lordship. And these income tax returns are of earlier year, Lordship. They have not filed any income tax return for the assessment year 2016-17, though the deceased died on 29/7/2016. That was because the tax returns are filed in the month of March, if I'm not wrong, Lordship. And she died in July, but that return is not submitted.
Which year he died?
Yes, she died in 16, Lordship. 29/7/16, but assessment year, Lordship, is always of the financial year and assessment year. And Lordship, again, Lordship, Exhibit 32. This is also a salary certificate. That is at page 101 of the LCR, Lordship. It is overwritten, Lordship. Last pay, Lordship will find that the amount is overwritten. And court relied on these documents to come to the conclusion that 43 lakhs is the liability. Then Lordship, Lordship,
The total in exhibit 32.
51 and 52,
51.
1 and 2. But Lordship, they are again different from the other same salary certificate for the same person. They're giving different amounts for different amounts for different with different salary certificates.
Tribunal relied on which?
Tribunal relied, I think, on this 32, 31 and 32.
Where the salary is mentioned as
Lordship, paragraph 11 of the judgment. Service book was 31 since the research was a year. And then Lordship,
what is your submission? As it was overwritten, it should not have been.
it should not happen. And moreover, when there is this difference between salary certificate of the same person, Lordship, different amounts are given in the tax returns which are submitted, Lordship. The amount is coming differently. It is their own exhibits, Lordship. I'm not adding or subtracting anything. All these documents are giving different amounts as salary, Lordship. But the court has relied upon the highest amount. That is what is my submission, Lordship. Because the exhibit 16, 41,749, exhibit 17, 52,364. Then if we go by the income tax return, Lordship, the amounts come to 34,376 and 37,347. And if Lordship will take a PW3, he who proved the salary is vital at pay, revised scale of rupees 46,310 came into effect on 1/4/2016, and after one increment, the scale was 47,700 on 1/7/16. Whereas the exhibit 16 was dated 26/8/16. PW3, Lordship, who is the official witness, he submitted that revised scale came into effect on 46/10/2013 and in his chief itself, Lordship, and after one increment, the scale was rupees 47,700 on 1/7/16. Whereas Lordship will find that exhibit 16, that is dated 28/6/16. In that, the amount is not mentioned as 47,700. It is mentioned as 41,749. In every document, the income is different. That's why I'm trying to show, Lordship. And then, since PW3 exhibited the salary thing, Lordship will find in his cross-examination itself, the court has written, all the exhibits are under objection by insurance company on the ground that these are Xerox copies. It is mentioned in the end, Lordship. And he himself says net taxable income is rupees 26,068. I have no full knowledge regarding the exhibits. The revision was effected on 1/6. So, moreover, in his cross-examination, he submits, Lordship, in the end that I have no knowledge regarding the exhibits. He came to exhibit the exhibits to prove the salary and service book, but he himself says that he doesn't have any knowledge. And Lordship, Evidence Act, Lordship, I'm relying on this first judgment, Partha Pratim Roy, Lordship, photocopies are not to be considered. I've submitted that first judgment, Lordship will peruse. Here, our own High Court said that photocopies are paragraph 14, Lordship. It will have to be part heard.
when immediately so that it remains fresh.
He is busy, so let him fix the date.
Well, tomorrow,
No, tomorrow.
Lordship,
I'm sitting in division bench. Second half.
on 6th,
Six is.
of course, my lord, I may, on 6th, I may pray for accommodation in the time. I have certain matters fixed before the division bench. So therefore, some accommodation I may just pray for, but I'll
Let
finish
it
it.
13th,
I'll,
because
no, other matters I have just fixed.
13th.
Yes.
13th is Tuesday.
Yes, it's fixed. Your lordship can keep it 6th. I can finish it off, my lord. That will not take much of
No,
time.
I'll take time, na. You won't take time.
She has, I understand, my lord, she has already come to the end leg of her arguments.
Naturally, I've read the judgment. After that, what remains? I'll just present the.
On 6th, your lordship can keep it on 6th. We'll make an attempt. I think it will be through.
Because I want to finish it, Lordship. Every week it comes. And
If necessary, my lord,
something
I'll just
doesn't
make
happen.
a request for adjustment timing. Otherwise, I'm on 6th. I'm available. Only 2 matters are fixed for hearing before the division bench. That's why I'm saying.
RD the London Council for the Appellant. Also heard Mr. Minister of London Premier Council Assistant Prime Minister and Tarun. The hearing remained inconclusive. Then this matter will be listed again on 6th of August 2024 as part heard matter.
Okay, we have a small request to make, Lordship, in item number 24.
Well, in item number 21 and 2, that we did. I am told, my lord, the order is possibly already uploaded in the system. But there is some inconvenience on part of my instructing lawyer. He said that he will have some difficulty. And I also took consent of Mr. Sahavala. We are otherwise agreeable for a date on 3rd of September.
Yeah, Mr.
Lordship had fixed it on 22nd, but my instructing counsel is having some difficulty. We otherwise agreed on
You have
3rd.
informed Mr.
Yes,
Sahavala.
I have informed Mr. Sahavala, my lord.
Item number
21 and 22.
date to 22nd. 22nd.
We asked for 22nd initially, but later it
Now,
appeared
which date
3rd of
to-
September.
3rd September.
3rd September. Deeply obliged.
You will place this judgment
On that day, yes,
on
sir.
that day. I'm keeping the short note with the record.
Fine, Lord.
Item 24.
नहीं मूड है मेरा है हाँ,
Property.
हाँ, मेरा है
I is disposed of. Yes. What is
Lordship,
this?
item 24, Lordship. The stay matters, Lordship, basically, he is appearing for the petitioners. I am appearing for the sole respondent, Lordship. So, Lordship, this is a transfer petition. So, Lordship, I have a small prayer to make, Lordship, that we may be granted 2 weeks' time so that we can file an affidavit in opposition. Because there are certain facts, Lordship, disputed facts.
You are.
I am for the respondent, Lordship.
I am for the petition.
Mr.
P. Das, Lordship.
For petitioner who is appearing.
For petitioner.
I am my lord.
What-
Hey, how are you, my lord?
A. Hawari, learned counsel for the petitioner, also heard Mr. P. Das, learned counsel appearing for the sole respondent, who prays for some time to file an
Affidavit in opposition.
affidavit in opposition. The prayer is allowed. Let this matter be listed after 2 weeks.
Interim may be continued, Lord.
The interim order shall.
Lordship, may kindly fix a date, Lordship, otherwise
2 weeks.
2 weeks.
Dates, it is very difficult
Lordship, Lordship. I understand, Lordship.
on a date to be fixed to arrange.
Lordship. Oblige, Lordship. Oblige. Deeply oblige.
21, 22, 3rd September